Senhoras e senhores, bom dia. Sejam muito bem-vindos ao segundo dia do 8º Congresso CAM-CCBC de Arbitragem. Antes de darmos início às atividades, nós pedimos atenção a todos para alguns avisos importantes. Os idiomas oficiais do 8º Congresso CAM-CCBC de Arbitragem são o português e o inglês, com a opção de tradução simultânea. Na página de entrada da plataforma, você poderá escolher ouvir as palestras em seu áudio original ou traduzidas. Perguntas e comentários poderão ser enviados no chat ao lado do vídeo. Não se esqueçam de visitar a nossa área de patrocinadores e networking no menu principal. Nós agradecemos aos patrocinadores e apoiadores institucionais do evento. Convidamos para compor o painel presencialmente Patrícia Kobayashi, secretária-geral do CAM-CCBC, e remotamente Ana Serra e Moura, secretária-geral adjunta da Corte Internacional de Arbitragem da CCI. Também compõe este painel Gustavo Moser, advogado e acadêmico, e o nosso moderador, Remy Gerbay, sócio do escritório da Hughes Hilbert. Com a palavra o moderador deste painel, Remy Gerbay. Fremuth. Não vem.
Não. Duas mesmas palestrantes, está repetido um palestrante.
I would like to register our thanks to the team that organized this Congress, and I will take this minute to thank Ana Flávia, Leonardo, Andreas, and also, of course, our president, Eleonora Coelho. It is a true pleasure to be here and to share this panel with both Remy, Ana, and also Gustavo. We're here to talk about recent evolutions of arbitral institutions. And under the moderation of Remy Gerbay, we're going to talk about issues that institutions have been facing, such as diversity, transparency, guerrilla tactics. And so Remy have come up with a few questions for all of us to see what institutions have been doing and what they see to the future of what will be institutional arbitration. So I'm not sure if Remy were able to reconnect to us. Well, since we don't have
Isso antes nós voltaremos.
Can you hear me?
Now I do.
Yes. Yes. Okay.
Good morning, good afternoon, and good evening, everyone. And welcome to the third panel of this 8th edition of the CAM-CCBC Arbitration Congress. My name is Dr. Remy Gerbay, and it's my pleasure to moderate a panel on the topic of trends in institutional arbitration. The organizers, CAM-CCBC, have put together a great group of speakers to discuss these trends in institutional arbitration, and I look forward to introducing them to you in just a second. Now, on this panel, we're going to look at trends in institutional arbitration, including in particular what institutions do to innovate when they are dealing with changes with international arbitration practice. And this topic, of course, is very topical because, as you probably know by now, CAM-CCBC is in the process of revising its arbitration rules. In fact, I think as was announced to you on the conference yesterday, the CAM-CCBC has launched a public consultation in support of the revision of the arbitration rules of the institution. So this consultation is going to be open to you to participate until 18th of November 2021, in just under 1 month. And I think it's a unique opportunity for users of arbitration to contribute their views on what improvements they would like to see in the arbitration rules of CAM-CCBC. So please do feel free to participate in this consultation process. Again, the deadline is 18th of November 2021. Now, just a few words about the structure of the panel. As you know, this panel is going to be 90 minutes. We are going to follow what we call a roundtable format, where instead of having set presentations by the speakers, I'm going to take our very knowledgeable speakers through a series of questions and hopefully yield some interesting discussions and debates. We have reserved some time at the end of the session for Q&As by the audience, so do feel free to ask your questions using the chat function that you should see on your screen, and these questions will be put to me as we proceed with the panel. So without further ado, let me introduce our great panelists. We have, of course, Patrícia Kobayashi, who is going to be well known to you. She is, of course, the Secretary General of CAM-CCBC in São Paulo, and she's been at the institution for over a decade now, and during her time at CAM-CCBC, she also served as the institution's Deputy Secretary General. We also have Anna Sarai-Moura, who is the Deputy Secretary General of the ICC International Court of Arbitration in Paris, a position that she's held since June 2017. And before that, she was a counsel in the ICC Secretariat since almost 10 years ago. Last but not least, we have Gustavo Moser, who is a legal counsel in the Secretariat of the London Court of International Arbitration, the LCIA in London. Interestingly, prior to moving to London and joining the LCIA, Gustavo worked for another arbitration institution, namely the WIPO, the World Intellectual Property Organization's Arbitration and Mediation Center in Geneva. So all of this to say that we have a wealth of experience on this panel to discuss trends in institutional arbitration. I've counted, and I think that including my own time at the LCIA, we have something like 30 years of collective experience in institutional arbitration, which hopefully we'll be able to bring to the fore. Now, very last point before we start, a small disclaimer. The opinions expressed by the panelists today do not necessarily reflect those of the institutions with which they are affiliated. And of course, these opinions do not constitute legal advice or an official interpretation of the arbitration rules of the institutions with which they are affiliated. All right, so I think we're going to start with our first topic, and I'm going to direct a question to Gustavo in the first place, but everybody should feel free to intervene. And this concerns tribunal secretaries, which is really a new trend we've seen in arbitration practice, and a trend that arbitral institutions have adapted to, if I may say. So just by way of background, because international arbitration has become more and more complex, very often arbitral tribunals have resorted to hiring tribunal secretaries to help them with a number of administrative duties, like, for example, organizing a case file, coordinating meetings, drafting procedural orders. And this practice of tribunal secretaries became highly publicized a few years ago when, in the context of the Yukos case, the Russian Federation sought to challenge an arbitral award before the Dutch courts, which had been rendered against the Russian Federation on the basis, among other things, that the arbitral tribunal had delegated its personal mandate to decide the dispute to an assistant to the arbitral tribunal. And so that case generated a lot of controversy, in response to which there's been some attempts at dealing with that, including from institutions. So my first question, I guess, for Gustavo is, what's your experience at the LCIA of tribunal secretaries? I know it's an issue that's been dealt with recently in the rules. And what are the pros and cons, perhaps, of that practice of tribunal secretaries, Gustavo?
Thanks, Remy. I'm really delighted to join this distinguished panel of speakers. A warm welcome to the audience, and thanks for being with us today. Let me also thank CAM-CCBC, in particular the president, Eleonora Coelho, for the invitation, and all the supporters of this event. Remy and colleagues, I have just two disclaimers to make before I start my intervention. First of which being the one Remy briefly mentioned, the views I will express today are my own and do not necessarily reflect the views of the institutions with which I'm associated. And the second disclaimer, I'm afraid I have more questions to pose than answers to give today. So I hope this won't be disheartening. So if I may interject, Remy, tribunal secretary may be appointed in LCIA arbitrations. Just bring stats for the audience. Nearly 9% of the cases in 2020, LCIA cases had a tribunal secretary appointed, of whom 64% female. The LCA doesn't really have a rigid rules in relation to tribunal secretaries. What happened with the 2020 rules, which was an update of the rules, was that the Article 14A codifies the early guidance published in 2017. So there was a guidance on tribunal secretaries, notes for arbitrators, still available online, Section 8. And with the 2020 rules, Article 14A codified those practices. Essentially, I would summarize: the upfront communication is key. Identity of the secretary, tasks. The main point is really placed on transparency. Tribunals should not carry out any decision-making functions. Parties' consent will be required in respect of the identity of the secretaries, but also the permissible tasks, and also reinforcing the issue of not carrying out any decision-making functions. I think this is extremely important. And remuneration, of course, parties will have to consent to that. So summarizing would be emphasis on transparency. What are the tasks which will be carried out by the tribunal secretary? Who is the tribunal secretary? Tasks, permitted tasks, and the hourly rate. So we understand that if parties are aware of what is going on and can perhaps object to any of the proposed tasks, the risks of problems are greatly reduced. So these are if you like, the set out of the rules. Now, going back to your other part of the question, Remy, in terms of the advantages, I personally think that this is a way for more junior candidates to gain experience. There's also an element of legacy, a matter of legacy to train, equip generation of arbitrators. I think that's extremely helpful in that respect as well. But again, I think when it comes down to the LCA rules, so Article 14A, the emphasis is on transparency, on parties being aware of the tasks being proposed by the tribunal to be undertaken by the tribunal secretary, and of course, parties' consent will underscore all the appointment. So I don't see disadvantages. Of course, one of the things I wanted to perhaps discuss later on, Remy and colleagues, which is to some extent a segue to the next topic, is how to achieve more diversity within tribunal secretaries and whether institutions can do more in that respect. I see a number of advantages to having a tribunal secretary, but of course there are issues that have to be supervised, and the emphasis really transparency and whether the parties are consenting to those permitted tasks.
Thank you, Gustavo. And so is my understanding correct that in 2017, so there was this non-binding set of guidance notes issued by the LCIA, but that the big change, I guess, in 2020 is that much of the substance of these notes has been incorporated into the rules of the LCIA, the 2020 arbitration rules, which would be binding on the parties by operation of the fact that the parties have agreed to arbitrate under the rules. So there's a little bit of a movement towards perhaps more regulation, I guess, by institutions. Would that be fair to say that?
I would say it's really a codification of the practice. So that has been the practice since 2017, 2018, and it's still there. The note for arbitrators are still there. I think that is a way to bring awareness to those notes, which perhaps parties will not be immediately, let's say, aware to those notes. So in that respect, it's a great idea to incorporate, to codify the earlier guidance, which doesn't have change in the substance, but from a practical standpoint, it's better to have that incorporated into the rules rather than having as a separate note. But in terms of the content, is the same. I think it's now also for transparency reasons. It's better to have in there as well.
Thank you. So I'm going to ask Patricia and Anna perhaps to share their own experiences and views about how institutions can handle these tribunal secretaries and more broadly that practice of using arbitral secretaries. So I don't know if Patricia, do you want to start?
Well, thank you, Remy. Well, in my experience, the secretary of the arbitral tribunal is usually a tool in favor of efficiency, and it is common practice at CAM-CCBC also, as Gustavo said, that he sees at LCIA that 90%, is that right, of the cases they see arbitral tribunal secretaries. So the 2000...
9%. It's nearly 9%. Is just to be very precise.
Sorry.
It's 8.7, just to be very precise. 8.7, but nearly 9.
Yeah. Okay.
8.7.
Yeah, that's right.
Okay.
Yeah.
So I think I could say at CAM-CCBC we see a higher number of cases in which we see arbitral tribunal secretaries, and it is common practice, and we see in the terms of reference articles related to arbitral secretaries. And that is why the draft of the arbitration rules that is now under public consultation, we see, and this is the next step, the Article 42 on appointment of the Secretary of the Arbitral Tribunal, which pretty much encompasses all the experience we have seen in those terms of reference and in those cases we saw at CAM-CCBC in the past 10 years. So the provisions, they see the assistance to the tribunal under, of course, the supervision of the arbitrators, and the secretary should also abide to the same requirements of independency, impartiality, and confidentiality as arbitrators. They should also sign terms of confidentiality and independence. And of course, there's a specific provision in the draft that the decision-making duty shall not be delegated to the tribunal secretary and under no circumstances. And finally, an article on costs, that the appointment shall not result in additional costs to the parties except for expenses on with transportation, meals, accommodation, etc.
Thanks a lot, Patricia. Anna, what's your perspective? I know that the ICC obviously has, with its very large caseload, has seen tribunal secretaries over the past few decades. So what's the perspective from where you stand?
Thank you, Remy. And let me start by thanking CAM-CCBC, the kind invitation. Eleonora and Patricia, it's a huge pleasure to be with you, even though it's from Paris and not in São Paulo. As for the administrative secretaries, Remy, I think I must do another disclosure, which is if I'm here today, it's because I was myself an administrative secretary for a good number of years. And I think that gave me the experience that allowed me then to join the ICC. So I'm a huge supporter of administrative secretaries in general. When I arrived at the ICC in 2011, we reviewed the practice regarding administrative secretaries. And that was because we were seeing some kind of abuses in terms of payments made to administrative secretaries. Arbitrators would negotiate directly with the parties an hourly rate, and that would increase dramatically the cost of arbitration. That's when we drafted guidance. We do not have the guidance in our rules, but we have a separate note that encompasses the duties of the administrative secretary. And we forbidden basically the arbitrators to have different arrangements for payments to administrative secretaries, and just justifiable expenses are allowed under the current practice. I must say that at the beginning was quite difficult for arbitrators to accept, but for a good number of years we have not had any specific issue regarding administrative secretaries. And as it was already mentioned by Gustavo and by Patricia, I think the considerations are exactly the same. Transparency, that the arbitrators clarify with the parties that the administrative secretary will be nominated, has the same standards of independence and impartiality, and the kind of tasks that this person will be performing.
Thanks a lot. So I'm going to be a bit controversial, if I may. I'm going to play the devil's advocate, and I don't want to put people on the stand, but I've always thought that there was a bit of an inconsistency between saying, as some institutions, but not all, say that tribunal secretaries should have no involvement in the decision-making process of the arbitral tribunal, and at the same time requiring tribunal secretaries to be following the same principles of independence and impartiality as the arbitrators. It seems to me that it's either we are confident that the tribunal secretaries are not participating in decision making, in which case clearly there's no need for them to be independent and impartial, or they are, in which case, yes, it does make sense that they follow the same requirements as the arbitrators. And what I've noted is that there seems to be a little bit of a continuum of approaches by institutions. Some say, okay, we don't want the tribunal secretaries to have any involvement in decision making, and some others are a little bit more nuanced, and they say, well, it's for as long as there's informed consent, as long as the tribunal is very clear as to what is the scope of the work of the tribunal secretary, it's less of an issue, but there needs to be full transparency. And so I was wondering if anybody wanted to share their views on that point, but again, I don't want to put anybody on the stand like that.
Well, if I may,
Go ahead.
Yes, if I may, I don't really see. It's not contradictory if you say that they have to have the same standard of impartiality and independence, and also saying that they should not be involved in decision making. I think they play a relevant role in the arbitration in favor of efficiency, and they participate in the acts of the proceedings, helping the arbitral tribunals. But it's the arbitrator's duty to decide, and it's a personal duty. But on the other hand, we should, as a community and as institutions, arbitrators, lawyers, we should guarantee that this personal duty of the arbitrators is not tainted by a person that is closely working with the arbitrator, even though not interfering in decision making, but they should be impartial and independent. I think that's what drives institutions into those rules.
That's a great point, Patricia. So really the Rubicon, the red line that shouldn't be crossed is that, personal duty to decide the merits of the dispute, which really belongs to the arbitrator and can't be delegated to a tribunal secretary. So the small nuance I would give perhaps is that sometimes it seems to me that when a tribunal secretary, with the agreement of the parties and the tribunal, is asked to draft, for example, part of the arbitral awards, like for example the summary of the parties' submissions. It's a part of the arbitral award, which sometimes some arbitrators decide to delegate to their tribunal secretaries. It seems to me that in summarizing the parties' submissions, there is a bit of a choice that is exercised by the secretary, by the drafter, who's going to choose what words he's going to keep in the summary and what other aspects are going to be left out. So that can frame a little bit the reasoning. So for me, that boundary in decision making makes a lot of sense. Like you said, Patricia, there's a red line that can't be crossed, but I can't quite place where the red line exactly is sometimes. But I think we're all getting closer to understanding what is permissible and what is not with tribunal secretaries. I don't know if anybody wants to rebound on that. Otherwise, I'm happy to stop with my controversial point and move on.
Remy, and I also
Yes, Anna?
Remy, I just wanted to add that the supervision of the arbitral tribunal is also key, of course, because we could have an entire... Do you hear me?
Yes.
Yes.
Yes, so supervision, you were saying, was key. Supervision is key. Anna, you might wish to refresh your screen potentially. It seems to work, but supervision is a very good point, right? So it's not just that there's a red line of decision making that can be crossed.
Delay. I don't know whether you hear me now.
We do.
Okay. No. Yes. Exactly. Because the delegation of decision making, I do agree that it's quite difficult to set order.
So hence the importance of supervision. That's a great point. Thanks a lot. All right, so I'm going to take you now to a different trend in institutional arbitration that really is something that is very topical, and it's also something that institutions have had a huge impact on, and that is diversity. And I guess by way of introduction, I think it's fair to say that litigants or users of arbitration, what they care most about in an arbitration is to win. But at the same time, win or lose, I think all litigants want to know that they had a fair trial, that they had a fair chance at their, presenting their case. And I think this depends largely on the perception by the litigants that the arbitral tribunal has truly understood them and their perspectives and where they come from. And that's very unlikely to happen if the tribunal does not reflect the diversity of the parties themselves. Right? And that's the parties' linguistic, cultural, ethnic backgrounds, gender, etc., etc. It seems to me, but I'm looking forward to hear from you, that we've made great progress at arbitral institutions on diversity, especially on gender. So I was wondering if maybe Patricia and Anna, if you could share the views from where you stand on on diversity on this really topical issue.
So, Heavy,
Go ahead, Patricia.
You're perfectly right. We have seen exceptional progress in the past few years, especially after 2015 with the Equal Representation in Arbitration Pledge, the ERA Pledge. And according to the report of the Cross-Institutional Task Force on Gender Diversity in Arbitral Appointments and Proceedings, published in 2020, so 5 years later, the proportion of female arbitrators has almost doubled. So it went from 12.2% in 2015 to 21.3% in 2019. And at CAM-CCBC, since the approval of Administrative Resolution number 30 of 2018, that sets a goal to achieve at least 30% of women representation in pretty much every activity conducted by CAM-CCBC or supported or sponsored list of arbitrators, institutional appointments. The number of appointments of female arbitrators raised consistently. So since then, women's appointments registered a growth of 27%, representing nowadays 29.41% of the appointments. And in 2020, 42% of the presidents of arbitral tribunals appointed are women. And analyzing the arbitral tribunals constituted in 2020, 60% were mixed, composed of both female and male arbitrators. 35% were exclusively male, and only 5% were exclusively females. But if I may bring a different perspective, it interestingly, data shows that better women representation may also contribute to a better age representation, maybe closing the gap between generations. So if you analyze the numbers in age segments, for instance, focusing on arbitrators appointed in 2020 that graduated from college after the year 2000. So we're talking about arbitrators with age between 34 and 44 years old. And here we might be looking at the future. 50% are females and 50% are males. And those women represent 65% of the appointments of this very specific age segment. The second one, age segment, arbitrators that graduated from college between 85 and 2000. So we're talking about arbitrators with age between 45 and 59, and this is the most popular one. 75.9% are males and 24.1% are females, and those women represent 30.9% of the appointments on this very specific age segment. And finally, the older ones, arbitrators that graduated from college after 1985. So we're talking about arbitrators over 60 years old. 84% are males and 15.6% are females. And these women, they represent only 20% of the appointments. So that is why after the revision of the arbitration rules, we are discussing a project to review CAM-CCBC's commitment aiming to improving gender representations. And if I may, as Stavros, then he said yesterday, we care and act to promote diversity because it is just the right thing to do.
Patricia, that's great. I think the fact that age diversity and gender diversity go hand in hand is also a very important takeaway. I think I don't know if you have any stats or any anecdotal evidence, but would you say that arbitral institutions do a better job than the parties and the lawyers at promoting that diversity? You mentioned that the institution now is looking at gender equality in a list of arbitrators in the organs of the institution. But do you feel that parties and lawyers are doing as good a job as institution, or is there is this conventional wisdom that maybe institutions now are very much on board, but it's the lawyers that are, especially old male lawyers, who are not necessarily on board yet, and that's really dragging the numbers down? Is that consistent with your experience or not?
I think institutions, they sit in a privileged space in this specific area. I don't think parties and attorneys, they are not doing their jobs. I think institutions, they just have the privilege of thinking about and defending the method, legitimacy of arbitration, not thinking about a specific case. So it's a matter of changing the culture, and that's what we're trying to do.
Exactly. So institutions, they aim at preserving legitimacy. They want the best tribunal in general terms, whereas lawyers often just want to win, and they pick whoever they think is going to be the best arbitrator for them, and regardless of diversity sometimes. So Anna, what's your view on this? On diversity, in particular gender diversity? I know the ICC obviously is it's a topic that's close to the ICC. So what's the perception on your side? And I seem to have lost Anna. Anna, go ahead. You seem to be on mute, Anna. I don't know if it's coming from your computer.
Anna, it seems you're on mute, so could you activate your sound?
Do you hear me now?
Oh, yes,
Very
perfect.
Well. Okay, let's try again. I was saying, Remy, that when I joined the ICC 10 years ago, gender diversity was not at all an issue that we would discuss, which is quite impressive. The amount of progress that we have managed to do in 10 years' time. We were lagging behind for no excuses, of course. And I think that Alex was a huge support of this change in the way we were approaching these issues. As you know, we managed to have gender parity at the court in 2018, and that somehow supported the efforts that we were already doing in terms of increasing the appointments of arbitrators. Again, looking back, if we go back to 2010, we had only 7% of female arbitrators. Last year, we had 24. So we're making good progress. I'm not sure I fully agree with Tricia. I think parties and arbitrators, they can do more than what they are doing. The court only appoints arbitrator in 25% of the cases. So, a huge majority, 60% is parties and 15% is arbitrators. I think parties are doing much better. In the last year, actually, they nominated as many female arbitrators as the ICC, which was great. Co-arbitrators, though, are somehow lagging behind. So I think the institution is an agent of change. Of course, we have a duty to promote all sorts of diversity, and I think we will discuss that later on. But I think we need to count more also with the parties and with arbitrators. And now we have finally the first president of the court, a female president of the court in 100 years of history. Of course, we are happy with that. And one last thing that I think it's important, you cannot promote gender diversity by promoting always the same individuals. So we have a rule that we only appoint the same individual once per year. And that also helps us to broaden up the pool of candidates that we appoint in our cases.
That's great. So we're going to ask Gustavo. So Gustavo, I mean, I know you could say so much about gender diversity because the LCIA has got a deputy registrar, director general, and president of the court who are all women, which is quite impressive. But I wanted to ask you about other forms of diversity, perhaps. What do you have to share about this?
Right. I think I'm sure there's more to be done generally in terms of diversity. I think geographic, ethnic, racial, cultural, sexual orientation. But I think it's also, we should also be mindful that there are at times limits from an institutional point of view, some obstacles. Sometimes you have limited pool of available candidates for certain matters, specific case requirements. Often parties will agree attributes and qualifications of arbitrators that will have an impact on the available pool of names, nationality, the seat of arbitration, cost concerns. So this is just to name a few particular background expertise. So this taken together would mean that diversity is not achievable in each and every case. But I think there's more we can do as agents of the ecosystem for sure. Remy, I want to discuss diversity from a slightly different angle, which I think it's quite relevant at today's age. Diversity within backgrounds and professions. So really, with the arrival of these new technologies, new industries, the digital revolution we are experiencing, some mainstream technologies trend, artificial intelligence, cloud computing, quantum computing. Today, there's not only Internet of Things, but Internet of Behaviors, using data to and insights to influence behavior, cybersecurity, cloud, human augmentation, just to name a few of those, if you like, mainstream technology trends. To me, there's a fundamental question to raise in relation to that, which is, do we have arbitrators who possess the right technical skills to handle these prospective disputes? And I'm afraid I think not. Of course, this discussion will inevitably, Remy and colleagues, lead us to perhaps rethink legal education, which is a topic dear to my heart, but foreign to today's debate, sadly, maybe for a future event. But so really, my question would be, who's tomorrow's arbitrator? I think what are the skill sets required? These are, to me, very timely questions. I think we should think. We should also think of diversity in that respect. What are the backgrounds more likely to be required going forward for the types of disputes on the horizon? Mathematicians, engineers, physicists, disputes within their reach, their area of expertise, data breach disputes, we've seen more and more, crypto, space law disputes, why not, in the very near future. But also perhaps the new profession, cybersecurity specialists, robotics specialists, or designers of a smart and a clean environment, data analysts, so on and so forth. So that's, in my view, a discussion that is lacking at the moment. And I think that's, in addition to, obviously, all the diversity lato sensu, we all raise the points here. I think that should be added to the agenda.
So it's very interesting, Gustavo. You're talking about now an aspect of diversity, which is more like background, skill set, educational background, and how that type of diversity connects with the capacity of an arbitral tribunal to properly handle and decide a particular dispute. And I think it's very interesting. It does connect with, we have similar synergies, I think, in when it comes to certainly geographical diversity. I think you would very much argue sometimes that if you have a case that involves a certain jurisdiction, not having an arbitral tribunal or having an arbitral tribunal that doesn't have any arbitrator from that part of the world certainly can have a negative impact on the quality of the decision making in a way that will be very tangible, perhaps more so than for other types of diversity. So it's really interesting. It's the new frontier, I guess. So unless we have any other comments or questions, I wanted to take you to another trend that we see in international arbitration and how arbitral institutions have been responding or trying to deal with that particular trend. And that is what some people would call guerrilla tactics in international arbitration. I think for a number of years, we've now heard that from users of international arbitration that there is a sense that some users are using unfair, perhaps unethical tactics in order to win in the arbitration, often, but not always, respondents who are trying to prevent an arbitration from moving forward. And often these tactics have been called guerrilla tactics. So we've discussed that a lot, but here the purpose of this panel is really to focus on innovations within institutional arbitration frameworks. And so I was wondering, what is the role of arbitral institutions? What is it that institutions can do with their rules or otherwise to curb this practice of guerrilla tactics? And perhaps, Gustavo, I'm going to direct the first question to you, because the LCA rules, of course, have taken a very interesting approach back in 2014, which I think is still applicable in the 2020 rules, to dealing with ethics and arbitration practitioners. So can you just tell us a little bit of how it works in the LCA context, perhaps, and then we can have a debate about what else can be done or how things can be handled by other institutions?
Certainly. So I think the first question we should ask ourselves here in terms of the guerrilla tactics and I would say possibly a three-step question. What are the overriding objectives of an arbitrator? How to further this overriding objectives? What's the arbitrator primary concern, and is it to create justice? If so, how is this defined? I think if we all establish that these overriding objectives will be defined to conduct the cases without undue delay, being fair to the parties and proportion to the value of the matter, so dealing with cases justly and at a proportionate cost, then the point is the tribunal, arbitral institutions should really ensure that that they provide tribunals with the necessary tools to further to give effect to these overriding objectives when they exercise their powers under the rules. The LCIA gives arbitrators great latitude, Remy colleagues, to take a rather robust and minimal tolerance approach to reprehensible behaviors from authorized representatives. For example, an abuse of process, dishonesty, repeated floating of applications and challenges, or, for example, if the reason for protracted proceedings rests solely with the representative. Tribunals, therefore, are permitted to show really no sympathy, I would say, at all for a party who engages in a behavior, in a disruptive behavior or conduct. And arbitrators are allowed to impose sanctions, including on its own volition, which may also have a bearing on the costs allocation later on. So I would draw the attention of the audience to Article 18 of the rules, of the LCIA rules, and the annex to Article 18, which focus on the additional powers of the tribunal to address this unfortunate situations where a party engages in a conduct that is designed to disrupt or frustrate the arbitration. So it's ethical guidelines, as Remy briefly mentioned, Article 18, and it really each party should ensure that the authorized representative have agreed not to engage in those practices And I could list it here, for example, make a false statement to the tribunal or to the LCA court, use false evidence. We could think of interfere with a witness or intimidate a witness, initiate undisclosed unilateral contact with an arbitrator, for example, or any member of the LCA court. In terms of the examples of sanction, Article 18.6 of the rules set out 3 examples, one being a written reprimand. That's a possibility that the tribunal order a sanction against the party who behaved or engaged in a reprehensible behavior, written reprimand, a written caution as to the future conduct, and then a catch-all provision, any other measure necessary to fulfill the arbitrator's duty under Article 14, which is to conduct the case fairly, impartially, and also to adopt procedures suitable to avoid unnecessary delay and expenses. So really, again, focus on the costs, and our tribunals are also allowed to take the parties' conduct into account when they are awarding costs. So I will also refer to Article 28 of the rules. So these are the two provisions, the ethical guidelines, if you like, Article 18.6 in particular, and the annex to Article 18. And the consequences, I would also refer to the Article 28. So the conduct of the parties could be taken into account by tribunals. I would just make a brief point, Remy, if you don't mind. Just to this, of course, parties can bring this to the attention of the arbitral tribunal, whether the counterparty has engaged in any reprehensible behavior. However, again, Article 18 makes it expressly that the tribunal on its own volition could order that. So it's up to the parties to action this Article 18 and the related guidelines, but also the tribunal has a responsibility to oversee these provisions as well.
And thanks, Gustavo. And I think, again, to be very crystal clear, what was really different about this approach of the LCIA since 2014 is the idea of using an annex which contains ethical guidelines. It's an annex to the rules, and then a specific provision within the rules that expressly says that the arbitral tribunal has got the power to take sanctions, measures, in case it finds that the ethical guidelines have been breached. And again, this provision, yes, it mentions reprimands and caution, but it also has, crucially, this catch-all provision that says expressly that the arbitral tribunal has got the power to take any measures necessary to fulfill its duty, etc., etc. And so, I think, some might argue, and I'm looking forward to hearing from Anna and Patricia, that in any event, an arbitral tribunal has got duties to, and some powers to help move the case expeditiously, etc. But what's interesting here is an express provision that makes it crystal clear and beyond, this dispute between the parties, that the tribunal has got the power to take sanctions, as the case may be. I don't get the sense that this approach was followed by the other institutions. Often what we see in the world of institutional arbitration is when an innovation crops up in the rules of one of the institutions, often, later on the other institutions adapt that innovation in their subsequent amendments of their rules. I'm not sure that I've seen other institutions following suit, and but I'd love to hear from Anna and Patricia about guerrilla tactics, generally speaking, and what institutions can do to respond to that issue. Patricia, do you want to start?
Thank you, Remy. Sorry, go ahead.
No, please go ahead, Anna.
I was just going to say that indeed, yes, now that it's working, my connection is good. No, just indeed, it was not even a topic that was broadly debated in the context of the last revision of the rules. We do have some ethical guidelines in our note to the parties on ICC arbitration, but does not give the broad powers that you're talking about, Remy, to the arbitral tribunal. But however, I think two things are important, right? Because ethic guidelines go to both arbitrators and the parties. On arbitrators, we have expanded on guidance for disclosures, which you also find in our notes. And I think they are extremely important because on one hand, it gives more guidance to the arbitrators when they have to do disclosures. And the other side also, when there are challenges that are just dilatory, the ICC court can also take a more strict approach in rejecting those challenges if the disclosure duties were complied with. More on the council, there is a new provision under the 2021 rules that has been also quite debated, and that's the power that now the arbitral tribunal has upon its constitution to avoid conflict of interest to exclude counsel. And we already had also an encouragement to arbitrators to adopt the IBA guidelines on party representation. We have not yet seen any of these decisions by arbitral tribunals, but it has only been 10 months of the new rules. In any event, I was already seeing some of those agreements in the terms of reference themselves. And as Gustavo already mentioned, the arbitrators do have the power to take the behavior of the party into account for the decision on costs. And my impression is that even at that stage, normally arbitral tribunals depart from that. They feel it's not necessary at the stage of cost because they have discretion anyway to consider the party's behavior in that sense. But these were, our considerations, and we think that for the time being, we will not definitely have any clear guidance in the rules themselves.
That's very interesting. And so, Anna, just to maybe give a practical example to our audience about a situation in which an arbitral tribunal might feel justified to exclude counsel for a party. The typical example that we give is when a party decides to instruct an additional counsel at the last minute just before a hearing, for example, in order to artificially manufacture a conflict of interest against an arbitrator that they dislike on the arbitral tribunal, either to get that arbitrator removed or to postpone and delay the proceedings. And that has happened in the past. It's a famous case with Jan Paulsen, and so that is really, that was a starting point of that collective, thinking process that institutions have had about whether or not institutions, arbitral tribunals should be allowed to exclude counsel. I know that in some parts of the world, in particular in Switzerland, if I remember correctly, lawyers felt very strongly that it was not okay for arbitral tribunals to exclude counsel because parties had an unfettered right to choose their counsel, their representative in the proceedings, which is very cultural. I think it varies, greatly from state to state. But so I don't know, Patricia, if you have anything to add on this this issue of guerrilla tactics in general, or even excluding counsel, which is really a tough one.
Well, the draft of the arbitration rules that is now under public consultation, so please submit your comments to it. I think I could point out two provisions that might touch the case, and one clarification. When we're discussing the proposal for the new rule, guerrilla tactics wasn't really an issue raised by the commission responsible for the revision of the rules, specifically considering that there is an inherent authority and power to the arbitrators to decide and conduct in the best way they see fit. So the two articles, one, the 9.7, so I'm going to read it since we are under public consultation. The parties are prohibited throughout the proceedings to create an incidental fact that characterize impediment of one or more arbitrators, including under the claim of alteration of their respective representation, funding, or assistance. This is a more mild version of what we've been seeing in terms of reference we see at CAM-CCBC, because those provisions, they actually foresee powers for the arbitral tribunal to remove an attorney if such a situation where they have a change of attorneys to obstruct the proceeding, you might see in those cases. And the other one, and that we didn't have specifically in the rules, But now you see at the draft as the one that arbitral tribunals, when deciding on costs at the very end of the arbitration, they may consider the conduct of the parties and attorneys. And this one was also a provision that usually you see in the terms of reference in ongoing cases at CAM-CCBC.
I would just note that it's a very clever, approach that CAM-CCBC is taking to distill, the good practices it has witnessed over the years in terms of reference to improve its rules. It's a great way of starting the rules revision process, and that coupled with the consultation, I think, will make for very effective amendments, I'm sure. So I'm going to move now to another topic. Yeah, go ahead.
If I may interject just about the same topic, just Anna mentioned and Patricia, the authorized representative being taking effect with approval of the tribunal. I just want to also bring to the attention of the audience, Article 18 of the LCA rules is a rather lengthy article. The initial parts, Article 18.3 and .4, set down the provision of the tribunal approving or not approving any intended change or addition by a party to its authorized representative. Mm-hmm. So not only legal representative, but authorized representative. That was also a change. The 2014 rules had this provision already, and the 2020 changed to authorized representative, and the rest became exactly the same. So actually, that is also a practice of the LCA following the tribunal's formation. Any change or addition to the legal or to authorized representative will be notified and will take effect subject to the tribunal approving that change or addition.
Thank you, Gustavo. And so we're going to move to a last topic before we open up for questions. But that last topic is the push for transparency. So I think it's fair to say that it's difficult to talk about innovation within arbitral institutions without talking about the trend towards more transparency in international arbitration. And so perhaps starting with Patricia, can you tell us how important the topic of transparency is in Brazil, and specifically how it's been with CAM-CCBC and the current rules revision exercise? Have you seen a push for transparency as well, and how have you decided to handle it so far?
Well, short answer would be yes, we have seen a push in favor of transparency, and it is actually one of the pillars of Eleonora's mandate as the president of CAM-CCBC and the very first female president of CAM-CCBC in over 40 years. But if I may, a few steps back, I think I can say that most institutions are committed, very committed to promote transparency in arbitration. And we may differ on the perception of our users' expectations to the information we share, or we could be sharing. But I see a profound commitment of institutions on contributing as much as they can. So in this sense, I would like to share an important initiative we're conducting in Brazil. So 10 arbitral institutions, with the support of the Brazilian Arbitration Committee, the CBAR, are conducting a study on arbitrators' duty to disclose. To be more specific, we have a task force that is studying their cases to analyze mainly 3 points. The first one, what have been disclosed by arbitrators as soon as they receive notice of their appointment. The second one, additional information parties have been asking. And the third one, the arbitrators' answers to those questions. And we're still in the process of analyzing the data, but I'm certain that together, arbitral institutions can contribute to the development of the market, pushing the boundaries even further in favor of transparency. And maybe analyzing the data under the same methodology, which in my opinion would truly contribute to to transparency. So there was a discussion yesterday. Well, most institutions, they share information on arbitral tribunals. And with that information, you can have an estimate on how many cases an arbitrator have, or with whom they are sitting in those arbitral tribunals. But I question myself, how can we get this information to actually reach its purpose? It's something that I wonder. And the second point I would like to make in this theme, transparency, I dare say that publishing the awards is a practice no institution can avoid. So recently, CAM-CCBC was chosen as the institution that will administer arbitrations between participants of the open banking Brazil. In their arbitration convention, arbitrators must send a summary of the decision to be published to all participants of the market, save the confidentiality of the dispute and the case. And their main concern is to promote transparency of precedents and improving the open banking specifically. So in Brazil, we have a similar provision in the energy market, for example. That is why the CAM-CCBC is now on the verge of publishing the results of the study conducted with the University of São Paulo on how to publish the awards, and that's defining the methodology we're using to publish the awards. And that is why also the draft of the arbitration rules now under public consultation has the following provision, and I have it here. Article 39.2, the parties authorize the publication of excerpts of the award without mentioning or identifying the parties. For the publication of the award in its entirety, the CAM-CCBC shall first ask for the parties' agreement, except if the arbitration is defined as non-confidential in the terms of reference. I think there's a demand for more information. And it is my opinion that institutions are here to care for those expectations, of course, in a responsible way.
So it's a great point, Patricia. I think you put your finger on a tension that exists within arbitration practice between the fact that on the one hand, there is a call for more transparency for publication of decisions, not least to help precedents. In those jurisdictions where precedents are important, we know that there's been a call in England for publication of arbitral awards, specifically because the argument was that the common law was becoming impoverished, if you want, and weaker because all of the good decisions were made in arbitration and they were private and confidential. So there's that. But on the other hand, we know that we know from empirical surveys, in particular, a number of empirical surveys conducted by Queen Mary University, where I teach, that the users of arbitration really care about confidentiality, or at least privacy of the arbitral process, right? So there's a bit of a tension between the two, and finding the right balance is always difficult. So am I correct, Patricia, that the rule that we're contemplating at the moment with the new CAM-CCBC rules is an opt-out type of mechanism, where unless the parties, and the arbitral tribunal exclude the possibility of publication of excerpts in the terms of reference, then it will be possible to publish anonymized excerpts. Is that an opt-out mechanism?
Yes.
Is that what you're looking at? Okay.
Yes, for the experts, yes.
And for the full award, anonymized full award, is that an opt-in?
Yes.
Okay. Great. That sounds like you're striking a very fine balance there. That seems very sophisticated. Anna, maybe, because I know that that's a topic also at the ICC, so in recent years. So what can you share with us?
Indeed, Remy. I fully agree with what Patricia just said. I think it's not only a matter of meeting the parties' expectations, it's really protecting legitimacy of international arbitration. And if institutions do not do it, if we don't push for more transparency, eventually we will see movements that will impact legitimacy of international arbitration. And you know, I just read there was this interesting article in the Financial Times. Was called "A New Era of Corporate Transparency is Dawning," and it said that successful companies, and here we can say successful arbitral institutions, will be those who can do their business as well in the open as in the dark. And I think that's what, you know, Alexis in his 6 years of his term, and now Claudia, they have been focused on. It's really explaining how we take decisions in this house, providing, you know, guidance to the parties on how these decisions are taken, publishing our decisions on challenges, jurisdictional objections, publishing in our website information on the constitution of the Arbitral Tribunal, sector of industry, and now administrative secretaries. And this is to link with what we discussed at the outset of our conference. And this is a way also to, you know, to expand the pool of potential arbitrators, because you can see who has already that experience as administrative secretary. And now 2 years ago, 2 years and 10 months ago, we said that we will publish our awards in a non-sanitized way if the parties do not object to such publication. Here is one of these things, and you know, arbitral institutions are always in this situation, right? You want to push for diversity, you want to push for transparency. At the same time, you have a very important limit and cornerstone of international arbitration, which is parties' autonomy. So, of course, we give the parties a possibility to object if there is no confidentiality agreement in the contract or terms of reference. And so far, we will only publish the awards 2 years after. So we started publishing the first awards in April this year. And we have now 10 awards to be published out of the 350 awards that we have every year. So it's a small proportion. Excerpts we already published for, you know, a long time, and we don't request the parties any kind of authorization for that purpose, because we do have the powers under the rules, of course, anonymizing sensitive information. But for awards, it's a small step, but that we are confident that ultimately, you know, once the parties feel more comfortable with awards being published, that publish will increase, hopefully.
So Gustavo, to you, just because I know the LCIA as really a pioneer in this, you know, it was doing transparency before anybody else was doing transparency when it comes to challenges to arbitrators, for example. At a time where I remember people were pushing back, sometimes saying, "Why are you publishing challenges to arbitrators, you know, challenge decisions?" But can you tell us very briefly about how things are going at the LCIA on transparency? And then I want to take you to a final question. And in the interest of time, if we want to have questions for the audience, I just wanted to see where the institutions are going on disclosure of third-party funding for arbitrators. So maybe we can touch upon that very quickly. But Gustavo, very quickly on the LCIA and transparency, anything notable?
Yes, Remy, as you mentioned, LCIA is very much committed to transparency. Back in 2018, LCIA released the challenge decision database of 32 LCIA arbitration challenge decisions, anonymized challenge decisions. It has been a research tool for users, counsel arbitrators, really important to give guidance in relation to the standards of conduct, to how to provide a greater understanding of the reasoning applied by the LCIA court when it comes to challenges. I second your points, Remy, about the balance, reconciling these tensions when it comes to awards. I think there are some industries that are more or less concentrated, where it will make more sense to have awards published rather than other industries. And then I totally agree with Anna and Patricia. Parties' autonomy is really the cornerstone, and really the parties will have to consent to that beforehand, for sure. I don't have anything else to share, Remy, on that front, unless you have any other points to raise in that respect.
Just maybe a show of hands, you know, on third-party funding. You know, we have a lot of discussions. It's very topical, and institutions have reacted differently. I think we seem to be getting towards some sort of a consensus that it is important for parties to disclose the existence of a third-party funding arrangement and the name of the funder, in case it can create a conflict of interest for one of the arbitrators on the tribunal. because you could imagine a situation where a tribunal member was also active as counsel, for example, in private practice, could, through his law firm, receive significant funding for cases, and so this could potentially create doubts whether justifiable or not about the independence or impartiality of the arbitrator. So I get the sense that arbitral institutions are sort of lending on this, duty of disclosure. But have we reached that stage yet or not? What's the position under the existing ICC rules, LCA rules, and the forthcoming CAM-CCBC? Is third-party funding something that you've even discussed or not?
Maybe I can start with ICC, Remy. I think it was one of the most debated provisions under the new rules. And we discussed at length what was the purpose of this provision of 11.4 now under the new rules, whether we should request more information on TPF than just the identity and existence of TPF. And whether specific, players or agreements should be carved out from that provision. And ultimately, you see that the provision is quite short, and the objective of the provision is exactly what you mentioned, is to preserve impartiality and independence. Because what we were seeing is that these disclosures would come at the late stage of the proceedings, jeopardizing the constitution of the arbitral tribunal, with challenge, late resignations, and so on and so forth. So that was the main goal of this provision, was really, once again, to preserve legitimacy of constitution of the arbitral tribunal. And that's why we only request disclosure of existence and identity of the TPF. Of course, we know that there are many other issues that may arise in the context of a participation of a TPF in a case. And that was, again, we still believe that it's for the arbitral tribunal, once it's in possession of more information about the case, to assess if further information regarding the existence of this funder and the terms of the agreement should be requested from the parties. So in a nutshell, then, since 1st of January, there were already many TPFs disclosing this information in the request for arbitration, because, of course, TPFs, they have an interest in protecting enforceability of the awards and make sure that there are no conflicts of interest. So we were already seeing some situations in which this disclosure would be contained in the request for arbitration. But since then, we are seeing definitely an increase, and we have seen, 15 cases where the existence and identity of the funder was disclosed in the request for arbitration.
I don't know if we have any comments from Patricia or Gustavo. Otherwise, I'm happy to read a couple of the questions we've received from the audience. And I'm going to pick the...
I'm sorry, Remy.
Go ahead. Yes.
Because, a quick comment. So back in 2016, CAM-CCBC approved an administrative resolution recommending the parties to disclose information on third-party funding. And we are moving forward with this one. And it was under discussion in the Commission for the Revision of the Rules. So nowadays, the draft under public consultation says that parties must disclose the existence of third-party funding in the same sense as Anna said before. And with the purpose, and this is in the rules, to verify and disclose a conflict of interest. So since 2016, we had 10 cases in which parties disclosed information on TPF. And we didn't see any further problems, but we see that it is relevant information for the conflict check of arbitrators. So.
Thank you. So I'm going to read you, I'm mindful of time. We have only a few more minutes if you want to stick to our allotted time. I've got a question. I'm going to pick the more controversial ones. Question from Astolfo Caribe, who says, parties pay for lawyers, arbitrators, hearing rooms, administration, experts, and even coffee breaks. Why should anyone but the parties themselves have access to any documents of the case? Who is arbitration for? Question mark. I think it's a very interesting question because it puts the finger on the fact that at an individual level, parties, it's not in their interest for their awards documents to be published, but at a collective level, as users of the arbitration, like Anna said, if we refrain, if we shy away from engaging with a push for transparency, maybe there's going to be it's going to threaten the arbitral system as a whole, because we're seeing these attacks on privatization of justice, not just in investor state, but in commercial arbitration as well. We're seeing these attacks on arbitration, on the legitimacy of the system for right or wrong reasons. And I think we just don't have much of a choice but to engage in collectively in the debate on transparency. That's the way I would answer it. So another one that's a bit controversial, and I like it, from Matrim Cawthon. What are the limits of discussing diversity in a rather not diverse setting, such as most arbitral institutions or this panel itself? I think it's a fair point that are we well placed to talk about diversity when we have a panel that is primarily at least ethnically not equal? We have gender equality on the panel, but what are the limits of discussing diversity in non-diverse settings, I guess? I don't know if there's an answer from anybody. Go ahead, Patricia.
I'm not Caucasian. And I'm watching American also.
Yeah, I think the reality is if you want change... Yeah, go ahead, Patricia.
Yeah. No, it's just a comment. I find it interesting. It's not your place to discuss, but I think it's everyone's place to discuss. We should be discussing diversity in all its aspects if we want to develop the market, and that is something we should include in every discussion possible, just to protect not only the method but society in general. So that is the place in society.
And from a very practical point of view, if you want more diversity in arbitral appointments, whether they're made by parties, a council, or by arbitral institution, you just need to address it where in the only forum that we have, which is conferences with practitioners and arbitral institutions. So it seems to me that it's it may not be the best, but it's what we have, if we want to effect change. All right, so I think it's taking us to the very end of our time, unless there's any final comment or any final question. I think we're going to close. I will close with one remark again. As you've understood, CAM-CCBC is going through a very important rules revision process. There is this important consultation process that's taking place. The deadline to participate and contribute your views is the 18th of November, in just under 1 month. So please do take this opportunity to contribute to the debate. And for my part, thank you so much for inviting me. I had a great time. Thank you so much.
Nós agradecemos os integrantes do terceiro painel e seguimos com a programação do Grupo Jovem New Generation CAM-CCBC. Convidamos então para o palco Fabiana Leite para comandar os trabalhos aqui do Momento NewGen e a nossa convidada especial Adriana Braghetta. E participando remotamente, está conosco aqui a professora Catherine Rogers.
Olá a todos e todas que nos estão ouvindo nesse momento. Bom, se vocês sempre quiseram estar num círculo para ouvir causos de grandes ídolas da arbitragem, esse é o momento. Estamos aqui com a professora Catherine Rogers e com a doutora Adriana Braghetta, que nos contarão algumas histórias curiosas de sua vida. Vamos ouvi-las então. Professora Catherine, o que você tem para nos contar?
Thank you for inviting me. I especially love talking to young people about careers because and I think there's a lot to learn from hearing from different experiences. And so I started my career actually back when international arbitration was not taught in law schools. I ended up quite accidentally in Hong Kong. And I got there because I was asked, instead of starting as a lawyer doing litigation in New York, they had an opening at the law firm. Would I prefer instead to go to Hong Kong? The first question I asked was, what is international arbitration? And how do you do it in Hong Kong? After asking a lot of different questions, I did end up relocating for 2 years to Hong Kong. I did my due diligence on lots of different issues, and I came down to the decision that as long as the person I was working for was not a complete jerk, that this was going to be a really interesting, exciting experience. It was a really interesting, neat time to be in Asia and in Hong Kong. The only caveat, though, as long as the person I was working for was not a complete jerk, turned out to be true. I won't share all the details except to say that I was asked to do things that were not only unethical, but illegal. Which as a young attorney puts you in a very difficult situation, because just because you're young doesn't mean you're exempt from discipline by the VAR if you do something unethical or illegal. It's a very unusual and difficult situation because also if it involves client confidences, in most instances you cannot report to the professional authorities or to the criminal authorities what you've been asked to do that's illegal. But you do have to, under US rules and under most ethics rules, stop working on the case immediately. And let's just say that made for a very awkward conversation with the partner I was working for at the time. But I did do it. And I ended up having a rough couple years, really rough, probably some of the most difficult years professionally in my life. But I made it through. I ended up escaping, that law firm in Hong Kong, moving back to San Francisco for a great firm with amazing mentors. And just so you know, it all had a happy ending. I ended up a few years later getting emails from around the world from former colleagues at that Hong Kong office telling me, did you hear what happened to your former boss? He's in jail. As it turns out, he had been put in jail for exactly the same client matter, for actually different criminal conduct than he was trying to ask me or press me to do. But it was a really interesting experience at a number of levels, including the fact that, it ended up kind of a just result in the end. I ended up okay. He ended up in jail. But it was tough back then because it's hard to be a young woman in practice. It's even harder back then. We're really out, beyond your entire support system. At that time, certainly the office I was at was really kind of a macho mix of guys. There weren't very many women at all. And there wasn't really the kind of awareness, I think, that exists today about the need to mentor, about the need to watch out for women. And so I will say it sort of scarred me for life in both a good and a bad way. It was really, really tough to kind of come back from it in some ways. But it also is what got me on the path to researching and writing constantly about ethics and international arbitration, because it was really a formative part of my very first experience. And I will say, I think back to that when I have tough times these days, because most of the challenges or difficulties that I face today, I think back to those days, I think, oh, if you told me I'd have these problems back then, I would have been thrilled to hear how small and minor my problems today would be. And sometimes, people ask you, well, if you could go back and counsel your younger self, what would you tell her or him? And I always think I would tell her not to worry so much, to just kind of do what she thinks is best, commit to it, and work hard at it. But don't worry about everything else, because it doesn't always work out for everyone. I don't want to pretend that it's an easy thing. But that's really what's in front of you and all you can kind of control. And even if things don't work out the way you wanted them to, I will also say some of the best things that have happened to me professionally have been choices I didn't make, disappointments that I had that pushed me in a different direction than I thought I wanted to go. And you never know what would have happened if you'd gone down the other path. But I have to say, I feel incredibly lucky with how things have worked out for me, even though I didn't plan for a lot of the twists and turns that ended up taking me to interesting places. So I think that would be my kind of a general comment about how I got to where I am, and I'll turn it back to the moderators.
Obrigada, professora. Que história, que experiência, não é? E sim?
Incredible.
É interessante saber que mesmo
incredible was not the word I would have used back then.
Nos tornam mais fortes, não é mesmo? E mais preparadas para a vida. Adriana, o que você gostaria de nos contar?
Bom, primeiro, um prazer estar aqui com a Catherine Rogers. Interessante ouvir, né? A gente às vezes conhece as pessoas já estabilizadas na vida, e os jovens pensam nisso, né? Que nós não passamos dificuldades. Parece que já chegou no momento de só rosa. Primeiro, não existe esse momento só rosa, mas eu também tive experiências de vida muito interessantes e pensei em alguns causos mesmo, algumas experiências de certa maneira muito desafiadoras e hoje até engraçadas, né? Quando a gente olha para trás. Eu advoguei muitos anos antes da arbitragem se estabelecer no Brasil, no contencioso, fiz por muito tempo, ainda tem um ou outro caso. Eu me lembro que a primeira arbitragem, Fabi, eu queria falar 2 casos de contencioso depois de uma arbitragem. O meu primeiro caso judicial, fui na audiência sozinha, um caso pequeno, evidentemente, eu era recém-formada, toda preparada, tinha estudado o caso no detalhe, infinitamente, na vírgula, chego na audiência, era o dia do Jogo do Brasil. O Jogo do Brasil ia acontecer às 4 horas da tarde, o juiz trabalhista, vejam só, super atrasado. Eu estava num escritório muito pequenininho, que fazia de tudo. Juiz trabalhista super atrasado, a assessora dele começou a falar, olha, o juiz é muito nervoso. A senhora vai ter Jogo do Brasil aqui, vai ter um problema. Bom, dito e feito. Quando eu comecei a minha audiência, ele olhou para a minha testemunha, eu representava a requerida, a empresa, ele falou assim, a sua testemunha não vai falar isso, aquilo, lá. Evidentemente, tudo que a testemunha dizer. Senão eu vou prendê-la, doutora. E a senhora só vai conseguir tirar a testemunha do cárcere na segunda-feira, da delegacia, porque é Jogo do Brasil hoje. Eu, recém-formado, fiquei assim, ó. E eu não vou nem contar como terminou a história, mas me forjou. Acho que eu sou boa advogada em audiência, talvez pelo trauma que eu passei na primeira, né? Foi muito, muito traumática. Para alguém que sai da faculdade e fala, nossa, eu não sabia que juiz podia fazer isso. Constranger a testemunha descaradamente dessa forma. Mas um outro caso também muito interessante, esse caso talvez tenha me feito repensar muito o litígio judicial brasileiro. Um caso já, muitos anos de formada, mercado de capitais. Passei meses aí entendendo o caso. E aí, lá pelas tantas, o caso foi para o tribunal, fui despachar com o desembargador, relator, evidentemente não é até uma prática que talvez suma com o futuro, até com a experiência da arbitragem, mas fui despachar, era um senhor que estava para aposentar, muito renomado, e ele olhou para mim com muita franqueza e falou assim, doutora, ouvi, muita gentileza, vou ser muito sincero para a senhora, eu não entendo desse assunto, não vou entender e não tenho assessoria econômica que me faça entender desse assunto. Eu fiquei lá arrasada, virei as costas, fui para casa. Esse caso é muito curioso porque eu acho que é o link com a arbitragem, esse tipo de assunto, eu falei, nós precisamos ter alguma coisa a mais. Várias questões, não só a poder escolher alguém suitable, né, super afeito ao procedimento arbitral, como, de certa maneira, eu me senti um pouco também simpática e talvez touched, né, pela posição do juiz, que não pode nem abdicar um caso, que mesmo que ele não saiba, ele não tem a condição de decidir aquele caso, é um caso extremamente técnico, não vai ter assessoria técnica para decidir algumas questões. Então, esse caso me fez quase pensar em desistir de ser advogada, veja só. Ou de mudar de área. Eu falei, nossa, eu não consigo. Tem caso, ou vai ter caso, em que o judiciário precisa ser lotado, ou porque não tem condições de... todos os juízes não têm condições que eles gostariam de ter, de tratar com detalhe de um caso, precisamos de algo mais. E aí surgiu a arbitragem, e estou aqui, entre tantas outras coisas.
Olha só, já sabemos hoje que fujam da prisão a qualquer custo e também que existem outras opções melhores no judiciário do que o judiciário no litígio. E aí eu queria ouvir de você também, Adriana. Tudo bem, vamos para a arbitragem, mas e aí? Pode qualquer coisa?
Olha, eu, como todos aqui que estão, queria agradecer todos, a presidente, o vice-presidente. Então, a gente, ao longo dos anos, nós temos milhões de casos. E fora os que a gente ouve, ainda dos mais velhos, né? Não daria para, em uma tarde, falar toda a questão. Mas eu queria tratar de um caso que eu achei curiosíssimo. Eu já entrei como advogada nesse caso e os árbitros já haviam sido indicados. Árbitros de primeiríssima linha, tinham sido diretores de empresa de energia. O assunto era super complexo, centenas de milhões de reais. E escolheram ex-diretores, engenheiros, ex-diretores de empresa para serem coárbitros. E aí já tinha escolhido o presidente e eu sou contratada. Quando eu sou contratada, eu olho a formação do tribunal arbitral, quem que era um presidente? Um engenheiro. Excelentes naquilo que sabiam fazer. Mas, evidentemente, absolutamente inexperientes como árbitro e, sobretudo, um terceiro engenheiro, também como presidente. Aí eu, advogado da parte contrária, já nos descabelando, né? Já falando, olha, aqui, Houston Calls, a gente fez uma petição conjunta, tivemos 2 dias para fazer um termo de arbitragem, vejam bem, que tivemos que explicar para os engenheiros cada item do termo de arbitragem, e eles, com toda a boa-fé do mundo, mas aí nós sugerimos a eles, vejam, senhores, existe a figura do secretário do tribunal, tá, os senhores, nós vamos pagar adicionalmente, a gente paga, os senhores indicarem um secretário, às vezes olha, geralmente é um jovem advogado, experiente em arbitragem, tudo o que a gente falou, esses queridos engenheiros maravilhosos não vão conseguir escrever um laudo, né? E eles tinham dificuldade de antever isso. E não é que eles indicam um secretário, um quarto engenheiro. Amigo deles que tinha feito direito também. Bom, aí nós tivemos que ir para uma solução drástica, as partes se compuseram para trocar o presidente do tribunal arbitral e, felizmente, esse caso terminou por acordo. O que mostra isso, né? A importância, o cuidado de escolher árbitro e, evidentemente, a experiência também como árbitro, pelo menos na cadeira de presidente, é relevantíssima. É isso, Fabi.
Muito obrigada. Olha, mas eu gostei também desse relato para mostrar o quanto nós temos liberdade na arbitragem para também conseguir mudar alguns rumos e tomar as rédeas dos nossos litígios, né?
Isso aí.
Bom, foi um prazer estar aqui com vocês. Obrigada, professora Catherine. Obrigada, Adriana, por dividirem conosco alguns causos super curiosos da vida de vocês e com certeza aprendemos muito. Obrigada e bom resto de congresso para todo mundo.
Thank you all. Enjoy.
Muito bem, nós já estamos voltando aqui com as nossas atividades e organizando aí o quarto painel. Enquanto isso, eu quero deixar alguns recados para vocês. O Congresso CAM-CCBC de Arbitragem é um evento bilíngue e conta com 2 plataformas de transmissão, uma em português e outra em inglês. Caso queira se conectar na plataforma em português, se inscreva no nosso site em português no www.congressocamccbc.org.br. E se você quiser fazer a conexão em inglês, www.congressocamccbc.org.br/english. Perguntas e comentários podem ser enviados no chat ao lado, então, do vídeo. E lembramos ainda que as palestras serão gravadas e disponibilizadas na área de membros do site posteriormente. Em relação aos certificados, finalizadas as atividades aqui do 8º Congresso CAM-CCBC de Arbitragem, os certificados online serão enviados aos participantes por e-mail. Nós estamos organizando aqui o quarto painel para que a gente dê sequência às atividades aqui do 8º Congresso CAM-CCBC. Pedimos a todos a especial gentileza de preencherem a pesquisa de satisfação, que também será enviada por e-mail. Lembrando que saber a sua opinião, para nós, é de extrema importância para que a gente possa fazer sempre melhor aí nos futuros congressos que virão. Caso necessitem de suporte técnico durante o evento, nós pedimos que, por favor, por gentileza, entre em contato conosco pelo e-mail contato@transformaçãodigital, sem cedilha, sem acento.com. Agradecemos mais uma vez a todos os patrocinadores e apoiadores institucionais aqui do 8º Congresso CAM-CCBC de Arbitragem. Em instantes, então, nós daremos sequência ao nosso quarto painel. Nosso quarto painel ele tem como tema central a nova fronteira da transparência, bases de dados e suas implicações para a independência e imparcialidade. Já já nós estamos voltando aqui com as nossas atividades. Fique com a gente. Já estamos de volta à nova fronteira de transparência. Bases de dados e suas implicações para a independência e a imparcialidade é o nosso próximo tema. E assim nós iniciamos agora o quarto painel. Nós convidamos a participar desse painel presencialmente o nosso moderador André Abbud, sócio da BMA Advogados. E remotamente nós contaremos com Chiann Bao, árbitra, na Arbitrator Chambers, Jean-Rémi de Maistre, diretor executivo e cofundador da Jusmundi, e Catherine Rogers, professora de Direito da Penn State Law e fundadora da Arbitrator Intelligence. Também contamos nesse painel com Bertha Cooper-Rousseau, sócia gerente da Rousseau Cooper, e a moderação agora nas mãos aí do nosso sócio da BMA Advogados, André Abbud. Seja muito bem-vindo.
Obrigado mais uma vez e bom dia a todos. Good morning, everyone. Let me first thank CAM-CCBC and Eleonora Coelho for the kind invitation. It's a great pleasure to be here among you today. With an eye to the future of arbitration, this panel will address a new frontier of transparency: arbitration databases and their implications for our practice. We will organize our panel as follows. First, each of the speakers will make a short initial presentation to set the stage for our discussion. Afterwards, the panelists will answer and discuss a series of questions around this main topic. So we will start, you can see all the speakers. We will start with Chiann Bao. Welcome, Chiann. You have the floor.
It's a true pleasure to be here today with all of you. I am dialing in from Singapore, and the last time I was in Brazil was for ICA, which is probably exactly 10 years ago. So times have changed, but it's a pleasure to be here with you nonetheless. As you've heard, the topic that we have is in relation to transparency in arbitration, with a focus on the influence and impact of databases. I think this is a really unique topic, in fact, because indeed we've long talked about transparency in the context of international investment arbitration, and other panelists will speak more to that. But really, I think what we're honing in on today, in my view, is transparency in the context of international commercial arbitration. And the reason why I say that is because, in fact, the amount of data that we can get in international commercial arbitration has long been sparse at best. And that is, of course, as a result of the issue, one of the pillars of international commercial arbitration being confidentiality. And so until very recently, when institutions really started to make and evolve and grapple with the issue of needing more transparency for the purposes of legitimacy of the international commercial arbitration process, and also to ensure that there is more access to justice and leveling the playing field in an otherwise fairly opaque process, transparency as a term became more regularly referred to in the context of international commercial arbitration. And so a few questions that I've kind of thought about in preparing for today's session is, one, what is the driver for more transparency of international commercial arbitration? As I mentioned, part of it has to do with the legitimacy of the process. We are now in a very competitive field with international commercial courts, mediation, and other forms of ADR being more attractive to users because they are now offering features of international commercial arbitration that didn't exist before in their field, such as enforcement, such as the Singapore Mediation Convention, and also cost and time concerns are being addressed by these other forms of dispute resolution. And so there is now more competition, and so we have to reflect as an international commercial community as to what we need to do to ensure the legitimacy of our process. And institutions have come a long way in that regard. And part of it is because they are the holders and the keepers of data. And this is what I think we will explore in greater depth in the course of the discussions and the interaction that we will have later on, in terms of how to harness this information to enable greater transparency in international commercial arbitration.
Thank you very much, Chiann. On this same initial topic of transparency, we would like to hear from Bertha on transparency, specifically in the field of investor-state arbitration. Bertha, we still can't hear you.
Yes, there you are. Thank you.
Much better.
Thank
if you could start over. Thank you.
Yes, indeed. Indeed. As I was saying, it's a pleasure here to be invited by the Chambers, having visited there many years ago, along with Louise Barrington when she issued the first Chartered Institute of Arbitrators course on accelerated course for fellowship. Picking up on what Chiann has said, indeed, there has been a clarion call for transparency in international or investor-state dispute settlement. And this global clarion call has witnessed substantive progress in the decades-long need to address this issue. And it has been rooted primarily in the public's call for the legitimate right to know about investor-state disputes, which can impact their human rights, such as environmental, health, and safety issues, the development of infrastructure within communities, and the transparent and accountable management of their natural resources. In some developing countries, such as my own, information regarding governments' negotiations with foreign direct investors is excluded from the public, which has spilled over into limiting public's access to information on investor-state disputes. Clarion calls have been made for international organizations, such as UNCITRAL and ICIT, to rectify undue blockages public's legitimate right to know about investor-state settlements. These calls for transparencies have been founded in the perceived need for greater efficiency, accountability, and predictability, have gained in recent times much, as I've said, momentum. For instance, UNCITRAL's response to the call was culminated in April 2014 with its rules on transparency in treaty-based investor-state arbitration. These rules provide for the publication of exchanging an investor-state arbitration, which includes written submissions, exhibit lists, transcripts of hearings, submissions by third parties, to name a few, and also public access to hearings. ICIT's response to this clarion call, apart from parties' agreement and treaty provisions, transparency that exists in ICIT's arbitration, controlled by the tribunal's discretion, ICIT presently allows access to hearings if agreed by the parties and the Secretariat, and requires the Secretariat to publish requests to arbitration, the constitution of the tribunal, and awards. Even when parties do not agree, the publication of an award it publishes excerpts from the award's legal reasoning. So there is some limited sharing of the data within the domain. However, these provisions are not as expansive as UNCITRAL's rules on transparency. And responding to the Clarion's calls for more transparency, ICIT has proposed amendments to its rules and regulations. And these amendments will align ICIT's arbitration rules with UNCITRAL's rules and reflect similar provisions discussed above. The question one has to ask is it enough? Although UNCITRAL's rules may respond to the Clarion call for greater transparency in investor-state disputes, party autonomy remains sacred and requires opt-in, thus limiting its applicability. Further, the Mauritius Convention on Transparency, by which states agree to the application of UNCITRAL's rules on transparency prior to April 2014, has 23 signatories, but only has been enacted domestically in 9 states. And as mentioned above, UNCITRAL's rules publication of documents and public access to hearing is subject to exceptions for confidentiality or protection of information. This consists of business information, such as intellectual property, trade secrets, and information protected by being made available to the public under the investment treaty in questions of laws applicable to the dispute. With this in mind, and to avoid any state circumventing the public's right to know by veiling information behind domestic confidentiality laws, perhaps the clarion call for transparency should now target the creation of model transparency rules for investor-state settlement to be enacted at a domestic level. Thank you.
Thank you very much, Bertha. On a slight different topic, we would like to hear from Jean-Rémi on the shared responsibility of all participants in building the global rule of law. Jean-Rémi?
Thanks, André. And I would like first to thank Eleonora and Ana Flavia for the invitation. It's really a pleasure to share this panel with such distinguished speakers today. And maybe as a quick introduction, because Chiann also discussed now that we discussed about commercial arbitration and not only investment arbitration, I wanted to share a little data, which is the number of awards in commercial arbitration and investment arbitration that we could find on Newsmundi. And we have now twice the number of commercial arbitration awards compared to investment arbitration award, which gives an idea of how the availability of information is evolving very fast in commercial arbitration. But let's now go back to my topic, which is indeed the shared responsibility of everyone. The observation that we made is that the world today is globalized, and in order to make it work, to make this world work, we need a global legal system which is based on the rule of law. And I believe that progressively we will, enhance the quality of this legal system. And one of the features which is really necessary is the equal access to the legal information. And we are very far from that today. Already for any lawyer, finding information is complicated, but when you work in arbitration, in international dispute settlement in general, you spend a lot of time on that. And the main reason, we know there is confidentiality. I will talk about that, but even beyond confidentiality, there is a real dispersion of the data because there is no central administration which is in charge of disseminating the information. And so we believe that building this global rule of law is everyone's responsibility. And I will go through different actors quickly. One of the topic today is independence and impartiality. And this is the responsibility of arbitrators who have to be independent and impartial. This is an essential feature of a fair trial, and it has to be, we need a possibility to verify it. Of course, we know that in arbitration, reputation plays a major role, which in a way, plays as a kind of check and balances. But the real check and balances is the work that counsels parties will do to verify this independence, this impartiality. And in order to be able to do it, they need to have access to information. And that's where the role of institution enters into the game, because so the responsibility of institutions today, I believe, is to ensure the maximum level of transparency, while protecting, of course, confidentiality and even privacy that we don't discuss so much. So what transparency are we talking about today? First, there is, to be very concrete, there is a publication of the name of arbitrators, counsels, experts, and some basic information about cases. Let's be clear, I think there is absolutely no impact on confidentiality of cases where we discuss this kind of transparency. It's only publishing some information that will avoid a conflict of interest. And several institutions, have decided to do it for almost all their cases. It's the case of ICC, of CAM-CCBC, and some other around the world. And I think that clearly we are moving in this direction. Everyone is realizing that publishing this information do not harm confidentiality and ensure that there will not be conflict of interest anymore. Then the other topic, which is more complicated, is the publication of awards. And we have three categories of award. There is a first category, which is composed of the awards that are not confidential. And we often forget this award, but there are many of them actually that are not confidential that can be published. So here there is a work to do to collect them and to publish them. And also to anonymize them, because even if the award is not confidential, we should not allow that an award is published with the personal data of all the witnesses. So I know that all over the world it's not the same, we do not have the same views on that, but the anonymization of the witnesses is something that is very important in our opinion. Then you have the award that were confidential, and became publicly available through municipal enforcement proceedings, for instance. Here, there is one first issue, which is to find them. And that's why, for instance, we built a partnership with the arbitration committee of the ABA in order to work with lawyers all over the world to find these awards that are not anymore confidential. And we found many in Brazil, for instance, thanks to the contribution of several people, including Karina Goldberg from FCDG, that I would like to thank, because she has been super active to help us identify awards that are not confidential anymore. And here again, privacy is an issue that has to be addressed. And then you have the awards that are confidential, but can be published through a more classical redacting process. This has always existed, but the issue is that it costs a lot. And for institutions, it's complicated to handle this cost. And that's why we work with institutions. It's just needed to help them go through this process, anonymization and redacting of award, using technology to make it more efficient, so it costs less money. And so if transparency is the responsibility of institutions, it's clearly not the responsibility of databases or legal tech company. I think our responsibility is coming after. It's to democratize the access to these legal resources that have been made transparent by institutions beforehand. And there are some important features that should be part of that comes with this responsibility. And one of them that I want to explain is, for instance, the open access. One principle that we decided to follow very strictly at Jusmundi since the beginning is to make publicly accessible to everyone online all the documents that we collect. So any award, even the ones that we struggle to find, if you search them on Jusmundi, if you search them on Google, you will be able to read them, to download them. I think it's part of making this really not only available but accessible to everyone, using a new kind of model that can help moving forward in this direction. I will not say more for this quick introduction, and thanks again for the invitation.
Thank you very much, Jean-Rémi. We'll get back to some of the issues you raised in a moment. But first, we also want to hear the initial remarks by Professor Catherine Rogers.
Great. Well, let me add my thanks for the wonderful invitation to what is always a terrific Congress, and disappointed that we're not there all together live, but it's quite an impressive feat how they've organized it. I wanted to actually maybe close the opening remarks with a slightly different perspective on transparency. I want you all to imagine back 20 years ago, and if my math is correct, we're just about 8 months shy, if we go back 20 years, to when Brazil actually signed the New York Convention. And 20 years ago, international arbitration looked radically different in terms of transparency. It was, in many ways, a secret practice that not many people knew about, and not many people could know about. And I'm not talking about awards that announce the final outcome. I'm talking about how, what is terms of reference, I suppose, were available in an ICC treatise. But most of the nuances, most of the practices that exist today and are well known, are generally followed, were a mystery back then. I mean, if you can imagine, this was back before the very first Gary Born treatise, right, which we all go to when we're trying to look things up. And so the problems that Jean-Rémi talked about trying to find things from different places was dramatically worse back then. It wasn't just that you couldn't find previous cases, but you couldn't even look up basic ideas about, what is a red fern schedule. And the way the arbitration community has, in many ways, for the past 20 years, filled in a lot of this black box is exactly through conferences like this, where people exchanged on an informal and ad hoc basis examples and experiences. It was through a number of publications by, now we see today, for example, an explosion of sources where not only the top practitioners are publishing leading treatises, but many prominent arbitration practitioners are publishing treatises in various fields. There's an explosion of dissertations coming out, excellent works by younger scholars. There are articles that fill the journals, and of course there are blogs, and now with Jusmundi's wikis, right? So there are all sorts of sources you can use to look up even just basic terminology, which 20 years ago were just not there. It was a secret practice in a black box. With the advent of more awards coming online, which is clearly an exciting development, I again agree that it's about one of the challenges is getting them all not only available in one place, but accessible. And I'm going to add a few additional points to that. One, I think, is especially as we link the idea of transparency to the idea of democratization and to the idea of diversity. One of the biggest changes I think we've seen in these past 20 years, perhaps marked in part by Brazil's coming fully into the international arbitration community, is we're generally seeing a broadening and a flattening of the community. There are a lot more countries, a lot more practitioners, a lot more arbitrators from countries all around the world practicing in this area than there used to be. And that puts a lot more pressure and expectation on transparency, because these new players have to be able to understand what the game is and how you play it. And so when we talk about the legitimacy in international arbitration, it's talking about making what used to be secret practices known behind closed doors by only a handful of practitioners accessible to everyone. And one of the ways I think we will see hopefully more in the future is with language. So one of the things that I think is very true of arbitration in Brazil is it's an example of a place where many important, prominent, big stakes arbitrations are happening not in English, but in Portuguese or in Spanish. And the ability for the arbitration community to both acknowledge and bridge the gap between English and other languages and make information available, not just to people who don't speak English and speak only other languages, but information produced, trends that are produced in other parts of the world that are non-English speaking, bringing those ideas into international arbitration and to the formal parts of the arbitration rulemaking community, I think is an important part of transparency. And then the final point I'll make in my opening remarks is maybe a little controversial, but I'll throw it out there anyways. As I've watched the UNCITRAL ICSID Code of Conduct evolve, and as I saw the original requests, instructions from the states in the drafting process, what really struck me is that it was not, or not primarily perhaps even, about regulating arbitrators, so much as it was about, or at least equally about, transparency. When I saw the state expressions of what they wanted arbitrators to disclose, I think it was a vicarious or an indirect expression of frustration with their lack of ability to access that information in a way that they could easily digest and understand it. And so I think the original conception of the code was maybe we can just, in a sense, put the burden of increased transparency on arbitrators through this disclosure process. Now, for those of you who've watched the code evolve, I think that turned out to not be, at least in the original conceptualization, really practicable. But I think it still leaves open the question, the concern, that if we want people to have confidence and trust, not only in the arbitral regime generally, but also in the arbitrators, transparency really is linked to confidence in how you appoint the tribunal, in their outcomes, and in their ability or willingness to use the system more generally. And for those who have ever doubted, I think that transparency is essential to self-regulation, and that if you don't promote transparency and therefore self-regulation, you're going to end up seeing some form of attempted, at least, formal regulation. I think that code of conduct is a really great example of that struggle between transparency needed for self-regulation and the risks of a formal, though sometimes not entirely workable, external formal regulation by states. So transparency is actually something that we have to be creative in defining, in advancing, but it's something that actually inures to all of our benefit in one way or another, even if not in every single individual case. So those are my thoughts for the start of our discussion today.
Thank you very much, Catherine. We definitely have many interesting topics to discuss at this second part of the panel. And I would like to start by picking up on some of the topics that Chiann and Bertha addressed in their initial remarks about transparency, both in commercial and investor-state arbitration. And I'd like to ask Chiann and then Bertha to comment on Chiann's answer about the other side of the coin. In other words, are there any pitfalls to transparency in international commercial arbitration? And then Bertha, if you'd like to comment and then add your thoughts on any drawbacks to transparency in investor-state arbitration. And in particular, maybe you could say whether you believe that greater transparency can actually limit states' sovereignty. So, Chiann, what do you think? We still can't hear you.
Sorry. Yes, I hope that after you have heard all of our opening remarks, you are fully convinced that transparency is a good thing for both investor-state arbitration as well as international commercial arbitration. But of course, with all good things, there are question marks. And the question that's been presented to us is what the pitfalls are. And I think that we're looking at transparency as a concept and a term that's easily thrown around as what does it mean? And we've tried to define what it means in the context of our opening remarks. But the reality is that transparency, as alluded to in Catherine's remarks, it should be fulsome and should allow for the flattening of the institution of international arbitration, be it investor state or commercial arbitration. However, what this means is also that there has to be access to the information. And with issues such as language and incomplete information, skewed information, you can find yourself in a world where you have very good transparency on certain issues, but terrible transparency on other issues. And how does that issue play out in the benefit of the system? For example, if you are gathering only English speaking or English arbitration awards, or your surveys that you conduct or the awards that you collect are focused on, Europe or a certain region, what we know about this is that, in fact, arbitration is now global, truly global, and there are just as many arbitrations in the Spanish-speaking world, the Portuguese-speaking world, as there are in the Chinese-speaking world. And so how do we get that access to information to really better inform us as to what's going on the ground, not simply from a procedural perspective, but from a cultural perspective as well. And so I think that kind of pitfall is something that we all have to, first of all, be conscious of, know that it is an issue. And I'm sure, as with everything, there are ways in which we can address these issues. But I think that is something that needs to be addressed up front and acknowledge that there is the potential that you won't get fulsome information that you need to truly paint an accurate picture as to the legitimacy of the process and also the true figures and the true data that exists in the world.
Thanks much, Chiann. Bertha, would you like to comment on Chiann's answer and on the question?
Yes, thank you. I agree, Chiann, and particularly for developing countries that do not have institutions and include, for instance, commercial or investor-state arbitration and include clauses from an international organization. And when it comes to the selection of those arbitrators or even the awards or just the process, the country that has appointed and using an international institution, whether it's in a different culture or a language, will not have access to those information, especially if counsel representing the state or representing a party from one jurisdiction to the next. So I totally agree that these issues must be addressed cross-border and taking in consideration the points you've raised. As regards to the question regarding whether investor-state arbitration responds to transparency. Again, when you look at UNCITRAL, as it says, the rules are there, but there is instant teeth, meaning that unless countries, excuse me one second. Could you please ask the question again, sorry.
Sure. So I asked you specifically whether you believe that greater transparency can actually limit state sovereignty in some ways.
Oh, yes, yes, definitely. Yes and no. For the country that has enacted transparency provisions, or for instance, the 9 countries that have signed on to the Mauritius Convention or have adopted Article 1 of the rules, greater transparency may appear to limit its sovereignty, but at the same time, it attracts investors and also it raises the country's rating corruption index. As regards to countries that view transparency and provisions of UNCITRAL or with its proposed rules, and who opt out or just completely do not apply these provisions, definitely they will view this as a form of restriction to their sovereignty, yes.
Thank you very much, Bertha. Turning now to the databases themselves, there's a very hot topic, and strong evidence of that is that besides our question, we've got at least 2 similar questions from the audience already. So I'd like to address this question first to Jean-Rémi. Who watches the Watchmen? How can we guarantee that databases are not manipulated, or simply that the data is not wrong? And we received a similar question from the audience. Arminio Rodel asks, well, and adding to that, what about the risk of double hatting, conflicts of interest between professionals who work in those databases and have a parallel private practice? And Vitor Magnani also asks the same question around the risks, if there are any, of manipulation of the data. So, Jean-Rémi, what are your thoughts?
Thanks, André. And so I see 3 points to discuss. First one is quality of the information, of the data. Second is how do we ensure that the data is correct and not manipulated. And third, this question of conflict of interest. And to answer the first point, how do we ensure the good quality of the data? So I don't have the perfect answer, but I can tell you at least what we try to do to ensure this quality at Youth Mundi. And so this relies on 2 pillars. And the first pillar is technology, and especially artificial intelligence, and by that I mean natural language processing. So it means the capacity to understand the text of the document, to extract the relevant information. For instance, when you have an award, you want to know what are the national laws or the specific articles of the treaties that are applied. To do that, we have a team of engineers, more than 20 already, that is, building algorithms to understand in different languages. And this is clearly the most complicated part of our work, is to be able to do that in different languages. So we can understand and interconnect the data, and we can also, digitalize it, because when we work with an institution, what we get is like, this 400 pages PDF of a very bad quality. We have to extract, to correct the text, all of that is complicated, and we need to ensure very good quality. So we use also algorithm to verify potential mistakes to have the perfect quality. But despite what we could believe, technology is clearly just a little part of it. And the other part is legal expertise and people with a legal background, former lawyers who can guide the machine, explain what has to be done, but also verify everything which is not 100% sure. And more, 1/4 of the team of Jusmundi is composed of former lawyers who are coming from all over the world, because once again, we have this issue of, awards. I told you, we recently collected many awards from Brazil through the partnership with IBA. To be able to understand them, we need Portuguese-speaking people. So that's another part of it, having human in the loop and lawyers in the loop, if I can say, in order to verify everything which is done by the database itself. It makes it complicated. We need a lot of people to be able to do that, but it's necessary to ensure the quality of the information. And I want to jump a bit on what both Chiann and Bertha said about the question of the language and the origin of the information. And I totally agree. When we started Jusmundi, we had the choice of, maybe translating everything in English, so at least everyone speaking English can access the information. But we didn't buy into this vision that would say that, everyone practicing arbitration or the other domains that we want to do should speak English. So what we do is that our legal team is reading the award, adding, the specific keyword and legal concept behind each paragraph. And so when you use the search engine of Jusmundi and you search for a legal concept, like force majeure, for instance, you will be able to find relevant result in any language, in Portuguese, in Russian, etc. So this helps to find the relevant result in any language. Of course, it's not perfect. We still have a lot to develop, to improve, but that's the model we wanted to choose to ensure the quality, to ensure that we can search in different languages. I will be shorter with the two other points. How can we make sure that the data is not manipulated? There is no perfect answer either, but I think that transparency of databases themselves is one of the answers. So what we try to do is that to give, when we give you a list of cases of an arbitrator, you can access all the cases, all the information, reading the award when it is available. You have access to the original PDF, or when we work with institutions, the PDF is untrusted by the institution itself. And then you have the source. And it's like everything. It's like when you read an article and you need to make sure that what is written is true. I remember my former boss, Alain Pellet, was always telling me, you don't say anything without a footnote to explain where does it come from. So we try to apply the same logic, transparency and access to the source. And last point about double hatting between practitioners and people working at databases, I never really thought of it. So I told you we have 1/4 of our people who are former lawyers, but nobody is still a practicing attorney because people are working full-time with us. But indeed, it could be an issue. It could be the case also for us, for people are contributing some awards. Sometimes we ask ourselves, okay, if someone manipulates an award before to send it to us, we might publish something that is not reliable. So it is one of our fears. So we try to verify everything that we get, and maybe at a point institutions should think of something more reliable than PDF, because PDF can be manipulated. Maybe at a point we need something, with a verification of everything that is published from the institution, so we're sure there is no manipulation at the end of the day. Sorry if it was a bit long, but it was a complex question.
It was indeed. Thank you very much for the answer.
Thank you very much for.
So, does any of you would like to comment on the questions or Jean-Rémy's answer as well?
Maybe I can add just a few things since. Yeah, since I also have, I'm here on behalf of a very different type of database, but also one that has some of the same challenges. So arbitrator intelligence, and I've spoken in Brazil or with Brazilians much about it, and we have a lot of reports on Brazilian arbitrators. So some of you may know, others may not. What we do is we try to fill a gap that is left when you have collected publicly available information. And as we know, when you are selecting and appointing an arbitrator, you do your initial research on all the publicly available sources. That's how you create your long list. That's how you hone your long list of potential arbitrators down to your short list of potential arbitrators. But the way you traditionally make the leap from the short list to the tribunal is through research of a much more specific nature of stuff that is not publicly available, in part because even if awards on a particular arbitrator are publicly available, one, they tend to be very few. I think that it's been amazing what Jus Mundi and some other organizations have done to make what's publicly available more accessible and to collect it all in one place. But we're still talking about the very tippy tip of an iceberg. I think a reasonable estimate of the number of international commercial cases every year is about 12,000. And the number that get published every year are really in the hundreds. So even if we've made tremendous strides at collecting them and making them accessible and searchable, it's still a very, very much the major part that's under the water, right? So what arbitrator intelligence tries to do, because what you want when you're searching for an arbitrator is information that's underneath that confidentiality waterline. And so we sometimes say we've created sonar for international arbitrators. And what does that mean? The kind of information you use to get from your short list to your arbitrator appointment is topics that often aren't in the awards. For example, one that comes up certainly for Americans very frequently, and those who are up against Americans and want to avoid this is document production. Americans love it. They want lots of it. Most Latin American courts don't allow any of it. Most Latin American arbitrations, it's absent. But what happens when you have a party that's going to be asking for it, pushing for it, or perhaps your client who is from a jurisdiction that likes document production? How do you go about finding whether an arbitrator has a track record of granting document production, and if so, at what level? That information is usually not available, even in published awards, and it's usually researched through ad hoc research through professional networks. And this is where I think leveling the playing field becomes a really big issue, because if you are one of the major multinational law firms, or today, if you are a third-party funder, you have access in your files, information about thousands more arbitrations than even the publicly available databases. And you have information about the behavior of arbitrators that isn't clear from an award. So what we do is we have a platform online with a with a survey that has very carefully delineated questions in it that ask both for factual information, just to provide context about the arbitration, none of the facts that are in controversy or at issue in the arbitration, none of the legal issues that are in dispute in the arbitration, but enough facts to give a context to the evaluative and other procedural details that we collect this way. We then organize that information into reports on individual arbitrators that make that information, if you can't find it through your own professional network, available. I think we have some of the same issues that Jean-Rémi touched on. How do you, in the question originally, how do you verify the accuracy? And particularly since we ask evaluative questions, how do we make sure that parties who are unhappy with an arbitrator don't, in a sense, take it out in a critique of the arbitrator, an unfair critique? We have a series of policies and practices to ensure as much as possible. It's always, I think there's always open questions that are, room for improvement and will never be perfectly resolved, because that's the nature, I think, of data. There are always glitches in data. But we have a number of policies to prevent that. I'm actually very pleased to say that we have, through the various ways we can check on that, most importantly, by inviting arbitrators to review reports that we prepare on them. We've had very few instances where anyone has thought that there's been, significant inaccuracies or, more importantly, anything truly unfair with regard to conflicts of interest. I will also say I don't sit as an arbitrator. I've not sat as an arbitrator from my career. Never promoted myself as an arbitrator, in part because this project has been such a passion project of me for so many years in my career. But it is an issue. Conflicts of interest are always an issue. I think one of the things that Jean-Rémi perhaps left out is also, or I'm sure they also have this in practice, he just didn't mention it, is I think corporate governance issues set up practices that corporations have to follow in terms of not allowing anyone to use for personal or personal benefit or their own professional benefit assets of the company, and for a data company that the assets are the data. And then the other thing that I'm sure also, again, Yusmundi and pretty much everyone in the field does is non-disclosure agreements. So to some extent, these rely on the professional conduct of the people who sign them. But again, as I'm sure Yusmundi does, hire people with integrity, and we also have non-disclosure agreements to ensure that. And to date, again, I think we have an incredible team who I think is very much takes these issues seriously, and that's sort of how we deal with it. We're not nearly as big as Yusmundi, so far it hasn't been a sprawling problem for us.
Thank you very much for the comments, Catherine. When we have a follow-up question on that topic, when collecting data, databases face a typical collective action problem, and especially when you think that trying to get data as representative as possible of the iceberg you mentioned, Catherine, when you look at it from the perspective of the parties, they may ask, what's in it for me? Why should I share my data if I can use my own personal data to my exclusive own benefit, right? How do you see that, as I mentioned, typical collective action problem? And if Jean-Rémi could comment afterwards as well.
Yeah, so I think to some extent the case was made for this in our collective opening remarks about the benefit of transparency collectively, but that's the problem of a collective action problem. Everyone would love to see everyone else's data, but not so willing to sort of consent to having their own. I think that's a problem we very much see with regard to consent that's requested for publication of redacted awards. I think, for example, a lot of commendable efforts have been made by institutions. As a matter of fact, I remember being at a CAM-CCBC event. I don't want to guess how many years ago, but where there was a question: should arbitral awards be, published in redacted form? And I remember this very well because they had clickers in the audience. 85% of the audience said yes, resounding, absolutely yes. And then, because it was back when we had in-person events, there was this long line at the microphone of everyone who talked about how that's not going to happen, how difficult it is. People from institutions talking about how parties don't consent. And what we actually try to do is, with the way we collect this information, is strike a balance that we think should be more appealing to parties. Again, none of the facts at issue in the case and none of the legal issues in the case ever become disclosed. What we collect instead is this feedback about the arbitrator's decision making, contextualized but really abstracted from the factual and legal issues in the case. But we have a challenge in that our attorneys are very busy, that they and it's hard to get their attention. A couple of secret weapons we've found is, one, it turns out lawyers are much more willing to chat on the phone about these things and to essentially fill out our questionnaire by phone than they are just to go to the website and to a link. We do get submissions that way, but we're finding that it is a sort of iterative process, and they enjoy that process of talking with someone. And we actually get much deeper insights through telephone interviews. So we now have on our website, you can schedule a telephone call to give us feedback about your arbitration. That doesn't overcome entirely the question of, as you say, representativeness. And we disclose in our reports very clearly up front that the information we have is not necessarily representative. It can't be, in a sense, but what we are is a supplement to what's out there. So if you make your own phone calls around to your professional network, maybe you get 3 or 4 cases. We might only have 10 cases in our report, but that's 10 more probably, or at least many more than you were able to get by phone. The important thing, I think, in that context is to issue very clear disclaimers and qualifiers so that people are not misunderstanding what the data is that you've collected or how or what it means. And so we do have actually glossaries, an explanation of how to use this report, disclaimers at the beginning that these are not necessarily representative. Our other secret weapon, in addition to doing these surveys by phone, is we have tapped into what I think can be called self-interest. So I think some of our most avid fans are actually arbitrators. And when an arbitrator sees their reports, they say, oh, you know what? There are a couple of cases that you should know about because they're publicly available. Or, as Jean-Rémi said, if you just tell us the names of counsel who've appeared before you in the last few years, that information is not confidential. To say, this attorney appeared before me in the last couple of years. In fact, that is how Chambers does a lot of its rankings, is they collect that kind of information. And we find that when we write to someone or we reach out to someone and say, would you provide information, we get a much higher response rate if we say, will you give us feedback about this arbitrator rather than feedback about this case. And I think that's because still this is very much a human process, at least the way we approach it, because again, what we are trying to get at is information that's not necessarily in the award. It needs to be told as part of a story of this arbitrator's track record and feedback. And that human touch is really helpful. And I will say this in this context, which is different people have different sensibilities about whether they feel comfortable giving the names of even just attorneys who've appeared before them. I've studied arbitrator ethics all my career. I don't think it's confidential, but I appreciate that some people are uncomfortable with it. I will say this, male arbitrators so far are not uncomfortable with it. Women arbitrators only are. And I think that that's interesting and disappointing in the sense that there are a number of different theories that could go there, but we would like to get a lot more information on diverse, younger, newer arbitrators. And so we welcome those kind of leads on that we can track down and get that feedback on. But it's hard it's a hard fight. I mean, I think you hear that in Jean-Rémi's big picture as well. Even when you have this massive staff and technology, it's just a fight to get all this information from every possible source to refine it and analyze it respectfully, both for the users and for the sources. So I think that answers your question, I hope.
Absolutely. Thank you very much. Looking now at the issue from the perspective of arbitrators, or at least on a related concern that we may have or arbitrators may have on disclosing their information and the impacts on challenges and on the relative burdens between arbitrators and the parties themselves. So what does it mean to say that information is publicly available when we talk about disclosures? Must publicly available information be disclosed by arbitrators? How should we interpret and apply that standard of publicly available information when we talk about disclosures? And maybe Catherine could address this question, and Bertha could comment.
Yeah, I'll just say quickly from the perspective of arbitrator ethics and disclosure in that context, because I think it's actually an ongoing debate. It's not even, I think it wasn't even always the case, and still it's only recently been announced that English law is interpreted as requiring a duty of investigation by arbitrators. But the idea that you would have a duty to disclose without some sort of duty to investigate, the idea that you can't say, hear no evil, see no evil, all of a sudden you have no conflict of interest. Some courts have sort of said something to that effect, but I think the expectation is always that arbitrators will, do their best to try and make disclosures. but there are limits to what arbitrators can disclose. Beyond their resume and things that they research and find, there might be other connections that they, for example, don't know about, or that aren't clearly relevant to or perceived as relevant, I think in good faith, perceived as relevant to the arbitrator, but might be of interest certainly to the parties. And then we see now, I think, a number of cases, and to be honest, I'm not always easy with them, but I think they're sort of inevitable, that parties have some sort of duty to research, and if the information is publicly available, you can't challenge the arbitrator on it. And in fact, the rules are often written when you talk about the deadlines for challenges to an arbitrator. It's when the arbitrator makes a disclosure or within however many days from when the information became available to the party. And that's because we don't want parties to, essentially know about a conflict of interest, keep it in their pocket as a sort of insurance policy, and then take it out when there's an award that they don't like. But as more information becomes available, I think those rules were also sort of developed even before Google, right? It's hard to know when information should be deemed as publicly available. What if you're in a Chinese-speaking part of the world, your arbitration's in Chinese, your counsel are all Chinese-speaking, but the information was actually, pretty available in English Google? Or what if it's sort of buried? If you look hard enough, you might be able to pull up, if you knew the right words to search, you could pull up the case off Jus Mundi, right? But at what point do we, where do we strike the balance between the burden on the parties to do their due diligence and the arbitrator's obligations to investigate and disclose? I think as we see these transformations in the amount of information that's available and its accessibility in terms of its searchability and whatnot, I think we're going to see much more wrestling with where that line really is.
Bertha?
Thank you. And I think as we focus on international arbitration, for appointments, I think the burden is definitely upon the arbitrators to disclose. That burden has, one cannot, and you've pointed out, if an issue within the public and public domain is relative, but how would one know what has transpired in African, Asian, and a hearing is in Brazil? So I would say the burden now is much heavier upon the international arbitrators to disclose, as well as the parties, but more so for the arbitrators. I think it's reliance on the services offered by you and Jean-Rémy and arbitrating agencies expert wants to go beyond what may be available from your database, possible conflict of interest.
Thank you, Bertha. Let's now focus a bit on the impact of information databases on challenges of arbitrators. And I'd like to address this question to Chiann Bao. Can information resources or technology help reduce the number of unsuccessful challenges to arbitrators? And perhaps even more, do you foresee artificial intelligence deciding challenges to arbitrators solely based on data extracted from these services?
Yes, certainly. I think challenges are a great place to start you thinking about the beneficial use of this kind of information. As we've seen over the years, the institutions have certainly published data on the number of challenges that they receive. And in the general trend is that there are more and more challenges. What institutions have done is generally consolidated some of these challenges and put them into reports. Oftentimes, and certainly the trend is now, if it wasn't before, for institutions to offer, or at least by default, offer reasoned decisions on challenges. And all of this information is fantastically substantive information as to what parties, whether it's worth a party's time to engage in a challenge process against arbitrators with whom they think they have been wronged by. And so challenges themselves, I think, oftentimes serve as an initial guerrilla tactic, but when you look at the statistics and you see the number of challenges that have not been successful, you realize that really this is an unproductive use of anyone's time, including those that are trying to raise delaying tactics or be otherwise uncooperative during the proceedings. Now, the second question relates to whether AI can help with challenges. And certainly, I think AI, as far as I understand it, can do quite a bit these days in standardizing information and really processing information based on the data points. It's difficult for me to say, based on the number of decisions that are publicly available at this moment, to know whether challenges can be consolidated into sufficient data points such that an artificial intelligence mechanism would be able to streamline and come up with the right answer or a rational decision based on all of the reasoned challenge decisions that exist in the world. However, I do think that there are trends in terms of why arbitrators are challenged, and also how arbitrators and how the reasons that parties give to raise challenges. And so there are some common factors now that are being drawn out that I think could lend itself to AI decisions, and in fact could save a huge amount of time. I think oftentimes, these challenges are papered up, and really at the crux of it, it's a fairly simple issue, and it's a fairly simple question as to whether the arbitrator's challenge would succeed. But I do think that we could get to the point where, and this is a fairly discrete area, where we could get to a point where AI could resolve some of these challenges. But I think it's a matter of really, again, harnessing all the data that's out there. And at the moment, as far as I'm aware, there isn't sufficient data to really draw some conclusive and to gain significant trust in a computer system to generate reliable outcomes.
Thank you, Chiann Bao. Who would you like to comment on this question and answer?
Maybe I can say a few words, and I hope our tech team was not listening to you, Chiann, because otherwise maybe they already started to work on such a tool. But I agree that maybe for this specific case it could make sense. But generally speaking, I'm not really in favor of artificial intelligence entering in the decision-making process. And recently, during a demo, someone asked us, we have a tool on NewsMundi which is called the conflict checker that gives you the relationship between practitioners or with law firms, etc. And someone asked us, okay, but can you give like a level of potential conflict for each relationship, which we could do potentially and estimate, based on some interpretation of what is a conflict or not. But this is something we certainly do not want to do, because we don't believe it's the role of a machine to estimate if there is a conflict or not. And we already face an issue, and maybe I will jump on a bit on the question on what is an adequate or inadequate interpretation of the data that we discussed. That we see a lot today, and we discuss with arbitrators sometimes, parties coming to a hearing and using NewsMundi's conflict checker and saying to arbitrators, look, you have 5 lines on the conflict checker, you have to prove that you are not conflicted now. And and thank you, Catherine, for mentioning that. The disclaimer, we put them everywhere. We write, this is not a conflict. It's just a list of relationship. But users of the system are doing a bad interpretation of that. And so we don't want to take a step further and saying that, oh, this might be a conflict. No, we just give the information, and it's the job of the lawyer, of the arbitrator, of the tribunal, or the institution to do the analysis based on the information which is make easily available in a way.
I'll add two things.
Yeah.
If I could, just two things. One, going back to this idea of how far transparency has come, just so it wasn't lost what Chiann said, 20 years ago, even the parties who raised a challenge were not told why the challenge was either accepted or rejected. So it's a little hard to blame parties for making, I think, shot in the dark sort of challenges, because for so long, this was really one of the worst black boxes. I mean, assuming the challenge was made in good faith, you have a party who genuinely feels that they've been wronged by an arbitrator. And I think that, in commercial arbitration, the sort of, at least anecdotally, the strategic challenges, I think or the disruptive challenges for the purpose of disrupting, I think are understood, at least, because we don't have any statistics, as being a little less. But imagine you're a party, how you bring a challenge based on this what was then very vague standards before the IBA guidelines on conflicts. These vague terms, impartiality, independence, eyes of the parties. And you didn't know why the institution accepted or rejected it. Number one. Number two, this is an incredibly difficult area to ever develop artificial intelligence, because you have you sometimes have the same words, okay, but you have different parties, individuals interpreting them. The arbitrators interpret whether they have to disclose. The parties interpret whether there's a basis for a challenge. The institution rules on a challenge. But then and each of those use the same words, but with a slightly different, I think, perspective and often connotation, and for a different purpose. And then, of course, if you have a non-disclosure that comes up later in the arbitral, either set aside or enforcement, recognition and enforcement process, those are two, again, different lenses through which these same words are interpreted. It's a very complex and nuanced question, I think, with so little data to develop for artificial intelligence. On the other hand, I do think data and more reporting and transparency can make us much smarter and more, not only better at understanding when to make a challenge, but also identifying when challenges are truly bogus. The last thing I'll say is, for arbitrator intelligence, we actually put into our terms of use, if you use one of our reports, if you order one of our reports, you have to accept as a term of use that you cannot use it for challenges. So we just kind of make that off limits. Again, we're very different than what Jusmundi does, but it's something that we thought very strongly about, that our reports should not be used in the challenge process.
Thank you. Catherine, let us follow up on the use of artificial intelligence and the data in the decision-making process. How should we understand negative reactions to predictive and even descriptive analytics about judges and arbitrators? Many judges are uncomfortable with seeing their track records distilled down to data points, as we saw in France, as we saw also here in Brazil. Are there any privacy, personal data issues on the one hand? And on the other hand, are there free speech, democratic or private autonomy issues on the opposite direction? What do you think, Catherine?
Yeah, I think those are great questions. To be honest, and I cannot divorce myself from the fact that I, was educated as an American attorney. So I have probably a perhaps even exaggerated sense of legal realism and the idea, even if I have a tremendous also respect for judicial discretion, but to me, of course, judges are informed by their backgrounds. Of course, they have a lot of discretion in making decisions, which necessarily means there will be patterns as among or between different arbitrators. For example, Ravel law which is one of the leading tech companies doing predictive and descriptive analytics in judicial decision-making in the United States, can tell you that if you bring a motion to dismiss in the Southern District of New York, you have a 40% greater chance of having, or likelihood that it will be granted by Judge A rather than Judge B. I think actually it's more than 40%. If nothing else, I think you would want to know that to advise your clients strategically. I think also, again, informed by my sense of the role of courts in a democracy based on, again, my legal culture, I think that is very much a right that you should have as a citizen petitioning the judiciary if that's available. It is very different. For example, in the United States, there's a First Amendment constitutional right to access court files, not just attend proceedings, but access court files. And you cannot redact the names of or the information in a case unless there's a really good reason. It's surprising, again, from a very, I will maybe even provincial or blinkered. It's always amazing to me that courts in democracies will publish awards with redacted or with names of the arbitrators redacted. I think by the time it reaches the courts, it's important for courts to be passing on it. My, sorry, but American view is that that's of interest, and that's when that confidentiality needs to yield to public interest, even in commercial cases. But I know there are very different sensibilities about this, and I've spoken to judges in the United States who they don't have any ground or basis or opportunity to object, but they are also very uncomfortable seeing it as well, right? So every year at the end of the year, I see my teaching evaluations, and that you'd love to go back and say, well, wait a minute, that's not quite how it was. But everyone gets reviewed in this world, in most jobs, right? I think it makes sense. I think it makes sense that arbitrators are evaluated, even if it's just on the sort of dry data-based track record. Last thing I'll say, though, is I think predictive analytics, I think there's a lot of excitement in either predictive analytics or artificial intelligence producing outcomes. I think some of the prerequisites you need for that are just not available. You need a narrower set of issues and a large set of data. It's sort of the inverse in international, which is going to make that very far off, if ever possible.
Thank you, Catherine. Does anyone else would like to comment on this issue? Okay, then. We have a question from the audience to Jean-Rémi and his opening remarks. The question, which touches upon a very interesting discussion as well, is, doesn't the kind of transparency you mentioned, Jean-Rémi, move away from the fundamental reason why investors and commercial clients choose arbitration? There's no stare decisis in international arbitration. One tribunal is different from the other. Why should we treat arbitral awards as precedents and not keep them confidential and useful only for that particular case? What do you think, Jean-Rémi?
First, why I agree is that there is no stare decisis in international arbitration. I do not agree that it's not possible, and we should not have like an arbitral jurisprudence. And you know that it appeared in investment arbitration because the number of awards compared to the diversity of the cases was important. And I think that in commercial arbitration, with now the quantity of information that is being made available, we might see progressively more and more commercial arbitration awards that are referred to for substantial matters. And now we have like between 10 to 15% of the commercial arbitration awards that are made available at a point. So this is a game changer, and I think it's changing how we will see this question of arbitral jurisprudence at a point. But then I totally agree with the person who asked the question that confidentiality is an essential feature of arbitration and should be preserved. And in my initial remarks, I tried to explain, how we can work with confidentiality to still publish a lot of information about arbitrators, etc., about publishing what is not confidential. The awards that are made public through enforcement proceedings are not confidential anymore. And parties know that at a point, this might go out if they need to go to enforcement in the US, for instance. And then redacting is also a powerful tool. Of course, it's not always feasible, because when you have an economic sector where you have two major actors and it's super obvious to know, who are the companies, you have to redact so much that you don't keep a lot of information, but this information is still available. So just to sum up, I think indeed confidentiality has to be preserved, but there is a lot that is possible to do and that can still be done to enhance transparency and accessibility of the information while totally protecting confidentiality as an essential feature of the system.
Thank you. Does anyone would like to add to that or comment on the question?
I'll just add a vocabulary shift a little bit, which is, yes, we don't want or we don't expect that there will be formal stare decisis in international arbitration. But with greater availability of prior decisions, I think you increase predictability. And one of the concerns, I think, in international arbitration, certainly one of the reasons businesses choose international arbitration, is to manage risk. And you can only manage risk when you can, in a sense, have greater predictability in the outcome. And one of the great allures of international arbitration is that it increases predictability over, for example, if you have no dispute resolution clause and the case can be brought anywhere or multiple places in the world at the same time. But I do think that, to the extent that there are recurring issues in international arbitration, particularly procedural issues, we've benefited a tremendous amount from publication in various forms of procedural practices that have become essentially, they've sort of morphed into soft law, and in some instances, being adopted by courts into hard law. So I think that when you talk about confidentiality versus transparency, a part of the value of transparency is increased predictability for parties.
Yeah, and I would just echo that just a bit and add a bit to that.
Oh, please go ahead.
Oh, sorry, I was just going to add a bit to that and just indicate that even prior to these new policies from institutions for greater publication of sanitized awards, there were reports from institutions. For example, the ICC Bulletin had reports on sanitized awards, and oftentimes, as Catherine mentioned, these would be sanitized on procedural issues. And I think that's a great area and really ripe for the development of arbitration award precedents, whereby you have for example jurisdictional issues or specific procedural issues that may be decided either by the tribunal or by the institution, that will help with greater predictability as to what the outcome might be if a party decides to raise a particular procedural point or take issue with it, that the institution or the tribunal might have to deal with.
Well added, Chiann. Very interesting. We've come to the end of this panel, and I'd like to take the opportunity to once again thank you all for accepting the invitation to be speakers at this opportunity. Thank you, CAM-CCBC again, for the invitation for me to moderate the panel. And with this, we can end this session. Thank you very much.
Thank you.
Thanks to all of you.
Thank you.
Nós agradecemos aos palestrantes do quarto painel. Na sequência, para proferir a palestra magna de encerramento do 8º Congresso CAM-CCBC de Arbitragem para o tema O futuro da resolução de disputas internacionais, um sonho de primavera. Convidamos o especialista em arbitragem internacional, Eduardo Silva-Romero. Seja muito bem-vindo.
Thank you very much to CAM-CCBC for this very kind invitation to participate today in this session and close the debates. I must say that I was asked to speak in English. Let me say obrigado em português. Eu estou muito contente de falar hoje com vocês sobre o tema do futuro da arbitragem. The topic has been phrased in a way that I find a bit pessimistic. It looks as if we were in the middle of the winter and we hope that the spring will come back to the lands of arbitration. It is inevitable to recall a speech that was delivered by Professor Gary Bourne some time ago, in which he used the expression "winter is coming." And you may recall that "winter is coming" was this very important phrase often pronounced by the members of the House Stark in Game of Thrones. We should, however, analyze a bit this sentence, "winter is coming," because winter is coming was not, at least in Game of Thrones, was not an announcement of a dark future. It is not that the winter will be awful. Winter is coming was rather a sentence, a phrase, meaning that we shall all be aware that winter can come and we should always be prepared for it. So from this perspective, winter is coming is rather an optimistic phrase. And it is with this optimistic standpoint that I want to address the topic today. However, this pessimistic approach seems to be, to some extent, the attitude that is being adopted by many of our friends in the field of arbitration. And it is understandable from my perspective. And it is understandable because there are many dangers threatening arbitration. More precisely, you may find many papers about the threats that exist to the legitimacy of arbitration. But the word legitimacy in the phrase legitimacy of arbitration is not clear enough, and we'll try to come to that point later. There are two types of dangers that arbitration has always faced. It is not only something that is happening as we speak. The first type of dangers might be characterized as political threats, or if you will, external threats that may jeopardize the arbitration system. External threats because they don't come within or from the system of arbitration itself, but rather from elsewhere. And that elsewhere has traditionally been the states. The states, as you know, may decide through a law, through a court decision, that arbitration should end. And we all know that this threat is always there. Politics may change. States which liked arbitration and supported arbitration may suddenly decide that arbitration is not a legitimate means for resolving disputes and enact legislation forbidding arbitration in their territories. One example is very telling for us today. As you know, the European Union has decided, especially through its Commission and the European Court of Justice to vanish intra-EU investment arbitration once and for all. This is a political decision by a political organization, which is the European Union. So we should never, in my view, forget, first, that arbitration may vanish overnight if the states so decide. And secondly, that arbitration can only happen if the states support the system of arbitration. And it is that support which is essential, which to some extent is problematic because the state from which we need support is oftentimes a participant in arbitration proceedings. So we have a user of arbitration, the state entities, which at the same time may decide whether arbitration shall vanish or not. If the user is not satisfied with the system may simply disappear, at least in the territory of the state concerned. These are the external threats that were more important in another moment of history, but it's external threats that are always present because we know politics evolve. But there are also internal dangers or internal threats to arbitration. And these internal threats are interesting, first of all, because we're told they come from an entity called the user. I think we have invented an entity called the user of arbitration. We don't know what a user specifically is or who that person could be, but it is the user of arbitration who is entitled to criticize the system from inside the system. And from that perspective, there have been very important criticisms, I would say, in the last 15 years against arbitration, criticisms against which the system has reacted, and criticisms that, in my view, condition the future of arbitration, as we will see in a moment. There are four main criticisms which come from the inside of the system that have given rise to the main evolutions of the arbitration system in the last years. The first is the criticism that the system is not efficient. It is very long, it is very expensive, and all similar corollaries to the lack of efficiency. And as you know, too much has been written and said about this criticism. There are many different variants to the issue of efficiency, the question of the length of proceedings, the question of the flexibility of the proceedings, the question of the cost of the proceedings, etc., etc. Most recently, as we all know, the issue has been how adaptable arbitration is to be efficient, especially in our pandemic times. And we have all been very proud to see that the system is very adaptable in the circumstances, and we have all been participating in remote hearings. So much for efficiency. I don't think I need to stop and speak about it anymore. That criticism is being addressed, and the system has reacted with a lot of flexibility and adaptability to that. The second criticism is the one that was addressed by the panel just before my intervention today, is the criticism of lack of transparency. Transparency has become one of these truths of our modern society we cannot discuss or criticize. I mean, someone who will argue today that transparency is not a good thing will be considered as someone who wants to hide something, someone which is suspect of something bad. However, transparency needs intellectual analysis. First of all, we need to understand what transparency means. What is the extent of that trend towards transparency Is it only the publication of awards by Jus Mundi, by Jean-Rémi? Is it something else? Is it the possibility for the public to attend the hearings? So there is a need for analysis of the phenomenon so that the concept is narrowed down. Transparency is a word that actually was created to designate something of the tangible world. I mean, the water is transparent, but what could we say about an arbitration being transparent? So we need to do an intellectual exercise to be more precise. But the point I wanted to make regarding transparency very rapidly is that not the user, this abstract user I mentioned before, but rather specific concrete users seem to be very much against transparency, especially multinationals. I have had the opportunity to speak into some general counsel of some multinationals for whom confidentiality of the proceedings is indeed one of the advantages of the system. And so all this trend towards transparency in the future, in my mind, may see a reaction towards the users who will claim perhaps more confidentiality for especially arbitrations between private entities. The business is perhaps in those cases more important than what the public needs to know about these cases. The third criticism, which is very important as well, coming from the inside, is the lack of diversity in the system of arbitration. And I will come back to the lack of diversity later as well. And the fourth important criticism and last important criticism is that the ethics of the system need to be enhanced, reinforced. And this ethical component of the criticism is linked with the issue of efficiency, is also linked with the issue of transparency, to the point that arbitrators should disclose more information, as we heard also in the panel before my intervention. And it's also related to the issue of diversity. So I think that the main point of these internal dangers surrounding arbitration comes from the ethical considerations in relation to international arbitration. And especially diversity and ethics understood in the broadest possible sense are somehow the same concept. And they're somehow the same concept because both diversity and ethics are about the way in relation to arbitration in which we approach arbitration as a means for the administration of justice. We shouldn't forget that we are speaking here about a means for the administration of justice, that the word justice has a very important ethical component, and that a very important element of the ethical considerations surrounding arbitration has a link with diversity. This is to say, from another perspective, that arbitration is not just a business. It is not just a challenging and even fascinating intellectual activity or field. Arbitration as a means for administering justice is much more, or something much deeper than that a business or an intellectual activity. And if we all agree that this is a correct proposition, we should come to the conclusion that there is not enough discussion today in the field of international arbitration regarding what I would call the ethical approach to international arbitration. And the proposition that I would like to defend today is that the future of arbitration, having said what I just said, depends, in my view, on the ethical approach that we will have towards arbitration as a means for administering justice. And this proposition may have two different legs. The first is the importance of the ethical value of diversity. This will be the first part of my intervention today. And the second leg will be, or should be, in my view, the ethical value of impartiality. And that will be the second leg of my intervention today. Coming to the issue of diversity, diversity as transparency is a very difficult topic, and is a very difficult topic because it's difficult to discuss it. We all agree that diversity is important, as we all agree transparency may be important as well. But discussing the components of diversity is a very dangerous activity. It's a very dangerous activity. And the proposition that I think is important to define here is that by elevating diversity to the status of an absolute truth of the modern society, we are not able to analyze it to enhance diversity. And from that perspective, trying to analyze diversity in a few minutes, I would like to propose to you four series of comments in relation to diversity in international arbitration. Before that, I would like to make two preliminary comments. The first comment is that diversity is defined in many ways. So I chose to share with you today a definition that I found in a dictionary that we all know, which is the Black Law Dictionary, which says that diversity means, first, the fact of including many different types of people or things. Second, ethnic, socioeconomic, and gender diversity within a group, the combination within a population of people with different background or ideas. So this second definition seems to match what we all may think diversity means. Coming to the first series of observations about diversity, diversity seems to be all about inclusion. And we have all seen messages from Claudia Salomon, the president of the ICC International Court of Arbitration, which remind us of the importance of inclusion. So a diverse society would hence be an inclusive society. And it is perhaps in the sense that we see that many international organizations promote the creation of what they call a more inclusive work environment. And from this perspective, I believe that all the members of what is often called the arbitration field should be proud of how inclusive, compared with many other fields, the field of international arbitration certainly is. The point is that at times, given the criticism in the international arbitration field of lack of diversity, we may all have the impression that international arbitration is not a diverse field at all. But I can tell you that international arbitration is perhaps one of the most diverse fields in the planet. And I put to you that we should be proud of it. This is, in other words, the first point I wanted to make. I wanted to tell you that international arbitration is diverse, that international arbitration is not diverse enough, and then the future of arbitration regarding diversity may consist in finding ways to enhance the diversity that we already have in our field. The second point that I wanted to make is that many times diversity in the field of international arbitration seems to be reduced to the issue of appointment of arbitrators, and more specifically, the appointment of more women or more arbitrators coming from some regions such as Africa. But the issue of transparency is not only about the appointment of more women and more arbitrators from Africa and other regions. What, for instance, about the lack of women partners in the international arbitration teams in international law firms? If to come back to the second meaning of diversity that I mentioned, diversity is the combination within a population of people with different background or ideas. Do we really think, that the lawyers in the international arbitration teams really have different backgrounds or ideas? And I should pause here for a few moments. It seems to me, dear friends, that the field of international arbitration has set out some model paths to break into it. Are we, for instance, not requesting that the lawyers in these international teams have received an LLM in a common law jurisdiction from one of those elite institutions, mostly in the US or in the UK? Have we not created, in other words, in total disregard of the value of diversity, a model international arbitration associate? And I can stress at this point that diversity is, above all, about open-mindedness and having different people around. Another example, what about the fact that some international arbitration associates are not introduced to some clients because of the associate's origins or sexual orientations? I recall one instance years ago in which our team was told that we could not be introduced to a potential client because we were too exotic. And I used, of course, to laugh about this episode. We were exotic. What else could we do in the circumstances? But it's true that when I think now about this episode, I realize that the expression too exotic is full of violence. It is a clear manifestation of rejection of whatever or whomever is different. Another example, what about the very low number of women economic experts taking an active testifying role in international arbitrations? And I could give many other examples. And the point, I think, is that we can agree that appointing more women as arbitrators or appointing more arbitrators from some specific regions of the planet does not resolve the very complex diversity problem. The third point that I wanted to make is that diversity, just to use another metaphor from Game of Thrones, has many faces. Diversity has many faces. It comes from what I just said. Behind the word diversity, there are many different specific flaws in our culture or tragedies, to speak more bluntly. And I don't think that we can use the same lens to examine the goal of gender parity in the appointment of arbitrators with the need for including more African practitioners within the international arbitration field. And I don't think either that we can lump together the discrimination of practitioners belonging to the LGBT community with the discrimination of practitioners because of their religious beliefs. So we need to realize that by reducing the deficit of diversity in one of these issues, we are not solving the problem of diversity in other phenomena where discrimination happens. We should remember that diversity is a way to solve discrimination problems, and that discrimination problems are specific tragedies that the specific people are suffering. And the fourth last point that I wanted to make regarding diversity of arbitration is that this issue remains one that is the subject of many conferences and many speeches, but in which we haven't done much to solve it or to improve it. In a recent paper on the 2021 ICC rules of arbitration, I wrote that while this distinguished arbitral institution had introduced specific rules in order to improve the efficiency, the transparency, and even the ethics of the ICC arbitration system, it has not added any rule anywhere to improve diversity. And the same, by the way, applies, I believe, to all other institutions in the market. And why is that? Why have the arbitral institutions not added any provisions in their arbitration rules to enhance diversity? Why couldn't they, for instance, add a new provision stating that in appointing arbitrators, the institution shall seek to realize the goals of diversity? That, in my view, would be a good start to enhance diversity. And then over time, some more specific rules, if necessary, could be introduced or practices could be adopted to produce, we hope, behavioral change in favor of diversity. So that's one idea. There are many other initiatives that have been undertaken regarding diversity, such as the pledge, which should be commended. But there are many other initiatives that we could adopt. For instance, if we agree that there is a model arbitration associate, in that case, we should try to give the means to those who cannot access easily to match that model, to try to access the education necessary to match the model. We should perhaps open our minds and accept to interview as associates people with atypical credentials. Or we should, when appointing arbitrators, not only consider every time women or people from some regions, but also simply people we don't know. We follow all the trend towards appointing people we know, and I should say we know well. But we should take the risk of at least interviewing a couple of new names every time so that we get acquainted with them and we can appoint them, perhaps not when we interview them, but in a future case. So again, we need to open our minds. Let me come now to the second issue, which is the issue of impartiality, which is another value of the ethical approach to arbitration. And I want to take advantage of today's intervention to recall a phenomenon which I believe is very damaging to the international arbitration system and needs to be redressed if we want that the spring of arbitration come very, very rapidly. And this is the phenomenon that I call the one of the proactive co-arbitrator. The notion of proactive co-arbitrator could have two different meanings. A proactive co-arbitrator could have first a positive meaning, and it could be a co-arbitrator who works a lot, who really helps the president of the tribunal in many of the tasks that are entrusted to the tribunal, someone who reads all the papers, who does the job. I believe there is a notion of a proactive co-arbitrator which is somehow positive, even if puzzling, at least to me, which is the one pursuant to which the proactive co-arbitrator it may be one who is responsible for making sure that the position of the party who appointed him or her will be properly considered by the tribunal. We all seem to agree that co-arbitrators have this additional duty to make sure that the party who appointed them will be properly considered as to arguments and claims by the tribunal. But we should also recognize that by saying so, we are somehow saying that co-arbitrators are not totally impartial because they have an additional duty that at least the president doesn't have. I always wonder why we don't simply say that all the members of the tribunal have the duty to consider fully all arguments made by all parties before them. That's probably better, is it not? But there is also a negative meaning of this expression of proactive co-arbitrator, which is a proactive co-arbitrator who adopts some behaviors that can be perceived by the parties. And these behaviors occur either during the oral pleadings of counsel or during the witness and expert examination. And let me give you some examples for you to understand what the problem is. Regarding oral pleadings by counsel, the proactive co-arbitrator, for instance, will interrupt counsel to cut the flow of the argumentation with some type of question. The proactive co-arbitrator will ask questions during the oral pleading in order to destabilize counsel. The proactive co-arbitrator will ask questions after the oral pleading of the party who did not appoint her or him in an attempt to help the party who appointed him or her by prompting counsel to adjust the pleading about to be delivered in connection with the question asked. I hope I was clear. And a modality of these three situations that I mentioned is particularly problematic from an impartiality perspective. That modality is that a co-arbitrator could make an argument against the party who did not appoint her or him orally in the hearing, and then it can ask the question to the counsel who didn't appoint him or her, which would be a leading question that can be answered yes or no. So I make an argument of the party who appointed me, and then I said to the other side, well, do you agree, yes or no? So that behavior I put to you is not good for the system. What about the interference with witness and expert examination? And examples of this interference could be the co-arbitrator who will interrupt the flow of a cross-examination conducted by the party who did not appoint her or him by asking questions at inappropriate moments. That happens. A co-arbitrator who will ask questions to a witness relied upon by the party who appointed her or him to undo what could have been accomplished during cross-examination, or to help the preparation of the redirect examination to be conducted by the party who appointed him or her. And third example, this interference happens also when the co-arbitrator will herself or himself conduct a cross-examination through leading questions of a witness relied upon by the party who did not appoint he did not appoint her or him. I can say that we may be happy with one of these behaviors by the co-arbitrator we appointed. We can be happy because it goes in the sense of the interest of our client. But we are very unhappy, and our clients are very unhappy when the co-arbitrator appointed by the other side adopts this type of behavior. And I've seen clients very upset vis-a-vis this type of behaviors. The user, the concrete user, not this abstract user I mentioned before, may be very upset. What are the solutions that I may propose to tackle this issue? There may be some practices or guidelines to adopt as to how a co-arbitrator should behave. With respect to the intervention of co-arbitrators on the occasion of oral pleadings by counsel, unless there is a pressing need for a specific clarification, questions by the arbitrators to the parties should only be asked once the parties have concluded their oral pleadings, for instance. The arbitrator should not ask questions in between oral pleadings, for example, after the oral pleading by claimant and before the oral pleading by respondent. And to the extent possible, all of the arbitral tribunal's questions to the parties should be channeled through the president of the tribunal, so that there is no suspicion that the co-arbitrator is acting in a partial way. Guidelines or practices relating to arbitrators' interventions during witness examination. Unless there is a pressing need for a specific clarification, arbitrators should only ask questions to a witness when the examination by all counsel is completed. Unless there is a need for a specific clarification that would justify asking a leading question, arbitrators should only ask open questions to the witnesses. Arbitrators should not cross-examine or re-examine witnesses, and to the extent possible, all of the tribunal's questions to witnesses should be channeled through the president of the tribunal for the same reason I mentioned. So I come to my conclusion. Both diversity and impartiality, at the end, as ethical values, are about open-mindedness. open-mindedness is, in my view, what has been characterized by Yves Derrance as cultural neutrality. And cultural neutrality or open-mindedness is essential to enhance and protect the legitimacy of the international arbitration system. So to come back to the title of this presentation, let me tell you to conclude that the future of international arbitration very much depends on the cultural neutrality and the open-mindedness of its participants. Thank you very much.
Nós agradecemos a todos e a todas os palestrantes e moderadores aqui desta edição. Agradecemos ao suporte dos patrocinadores e apoiadores institucionais deste evento. Por fim, nós agradecemos a presença dos mais de 1.600 inscritos que participaram do 8º Congresso CAM-CCBC de Arbitragem e convidamos todos para a 9ª edição do Congresso, que será realizado nos dias 17 e 18 de outubro de 2022. Presencialmente, como todos esperam e, claro, como todos desejam. Até 2022 e muito obrigado.